you. Yes, how are we?
Good morning, my lord. Usuala Wambara is my name.
So let me start with the case of Mr. Felix Nabuti. I don't know whether the council are around. Mr. Felix, okay, the claimant and the defendant's counsel are
the claimant's counsel is on the platform.
My lord, the defendant is on the platform. The defendant's counsel.
Okay.
That is fully compliant with that compromise, which council computer.
So Mr. Claimant counsel, can I check your appearance?
Yeah, respectfully, my lord.
Is this CK? Is this CK Makwe?
CK. Very well, sir.
CK Makwe.
Makwe, very well, sir.
Yes, for the claimant.
Very
yes,
well, my lord.
Yes, counsel for the defendant.
Record the please. My name is I.M. Akumuti.
Okay. Akumuti, for the defendant.
Yes, my lord.
So this is my judgment. But by its checkered history, this case was from its very beginning instituted on the 20th of September 1999 at the Federal High Court Lagos Division. However, it was transferred to this court in 2013, where Honorable Justice Lawal Mani late for the first time presided over the matter on 25th of July 2013. Upon his lordship's transfer, the matter was taken over in 2014 by Honorable Justice B.B. Kanyip, now the Honorable President of the Court. The record of the court also reveals that the matter was later assigned to Honorable Justice Asian on the 3rd of December 2018, where the case was struck out on the 18th of February 2019 for non-diligent prosecution. However, it was released on 17th of June 2019. Claimant then sought to amend his complaint and statement of fact by an application which was granted by the court on the 17th of June 2019. Similarly, on the transfer of Honorable Justice Asian, the matter came up for the first time before me on the 15th of February 2021. By its amended general form of complaint and other accompanying processes filed on the 9th of July 2019, the claimant asked for the following reliefs as contained in his amended statement of fact against the defendant. Number one, a declaration that the claimant is entitled to remain in the defendant for up to 35 years or has attained the normal retirement age of 60 years. Number two, a declaration that the purported retirement of the claimant at the age of 51 when he has neither served the defendant for 35 years nor attained the age of 60 years is wrongful and of no effect. Number C, an order compelling the defendant to compute and pay to the claimant the sums due to the claimant as salaries and allowances from October 1995, when he was wrongfully retired, to October 2004, when he attained the normal retirement age of 60. Number 4, an order compelling the defendant to pay to the claimant his gratuity and pension as they fall due. The sum of 5 million naira being general damages for breach of contract of employment. The sum of 600,000 naira being cost of prosecuting this action. The defendant in reaction to the claimant's suit entered appearance and filed a statement of defense on the 30th of September 2021 by leave of court. Meanwhile, the claimant also filed a reply to the defendant's statement of defense on 5th of October 2021, which was deemed as properly filed and served following an application for leave of court to that effect. I note that the defendant has filed a notice of perennial objection, NPO, which was agreed to be taken alongside substantive matter. Both parties incorporated their argument for and against the NPO in their respective final written addresses. The NPO dated 29 September 2021 was filed on the 30th September 2029, and it seeks for the following orders. Number 1, an order of this honorable court setting down for trial the issue of law raised in paragraph 15 of the defendant's statement of defense as to whether this action is not statute barred, as to rob the honorable court of jurisdiction to entertain the suit. Number 2, an order of this honorable court striking out, dismissing this suit against the defendant applicant for failure to disclose reasonable, cognizable cause of action against the defendant applicant. Number 3, an order of this honorable court for being statute barred and for being an abuse of court process. Number 4, an order and for such further order or orders as this honorable court may deem fit to make in the circumstance. Counsel for the defendant filed a 17-paragraph affidavit in support of the NPO and a written address wherein he urged the court to uphold this objection. In opposition to the notice of perennial objection, claimants filed an 11-paragraph counter affidavit and a written address in urging the court to overrule the NPO. I also note that the defendant has filed a motion on the 1st of December 2021, seeking to set aside the order for payment of cost of 100,000 naira against the defendant. The motion, which was supported by a 15-paragraph affidavit and a written address, was taken alongside the defendant's final written address. The claimant has, as usual, filed a 12-paragraph counter affidavit and a written address to the motion, to the defendant's motion. I will deal with the said motion in the course of my judgment. Case of the claimant. From the pleadings filed by the claimant and his testimony, he was at all times an employee of the defendant, who is a corporation in Nigeria and owned by the federal government. The claimant joined the service of the defendant company in February 1977 at the age of 33 years as a supervisor on grade level 10, when it was known as Nigerian Housing Development Society Limited, and later renamed Federal Mortgage Bank of Nigeria, FMMB. It is survived by the claimant that based on his conditions of employment, his appointment can only be determined after confirmation by giving 3 months notice or payment of salary in lieu of notice. It was also abided by the claimant that based on satisfactory work and his conduct, his appointment was confirmed and he was given a long service award by the defendant. Claimant averred that with the deconsolidation of the defendant in 1993, he was deployed to Federal Mortgage Finance Limited, FMF, which was created to handle retail mortgage lending and savings mobilization, while he assumed duty as Assistant General Manager. It was, however, stated by the claimant that the Federal Mortgage Finance Limited is now defunct and has been taken over by and consolidated with the defendant. That by his letter of transfer, the service of the claimant or the defendant will be treated as continuous with his subsequent service with the FMF Limited. Counsel said, claimant said in his appointment, claimant said that his appointment was governed by the conditions contained in his letter of employment and the staff handbook, that he was prematurely and unjustly retired at the age of 51 years instead of 60 years after serving the defendant for 18 years. It was the claimant's further averment that there was no reason given by the defendant for his retirement, which according to him constituted a breach of conditions in his contract of employment. Claimant has stated further in his reply to the statement of defense that the federal government of Nigeria in September 2000 merged the Federal Mortgage Finance Limited with the Federal Mortgage Bank of Nigeria to revitalize the mortgage industry. And as a result of that merger, all assets and liabilities of the FMF have been taken over by the defendant, and the legal personality of the FMF Limited was assumed in the defendant. That the FMF Limited did not pay the claimant his entitlement or retirement benefits, as the figures computed were not what was due to him. Case of the defendant would vehemently deny the claimant's claims, and they state in his statement of defense that the claimant was not at all times its employee, and that the employer-employee relationship with the defendant came to an end by virtue of letter dated on 2nd October 1993. That by a letter dated on 6 November 1993, the claimant was transferred to FMF Limited, where he was appointed as general manager. That the claimant disengaged his services fully from the defendant and became a full employee of FMF Limited, who is responsible for the payment of his emolument until he was retired as alleged. The defendant did not take over the defunct FMF Limited, neither was there a merger. That the claimant services continue with the FMM upon the transfer of his services, and there was a cessation of his employment with the defendant from that day onwards, and the claimant never returned to his services until he was retired with full benefit from the FMF Limited on 27th October 1995. It was the claimant contention that it is distinct and separate from the FMF Limited, and it never acquired nor had any control over the FMF Limited. Defendant also contended that the claimant's claim is a stale one, hence this court has no jurisdiction to entertain same. Trial commenced on the 5th of October 2021, where the claimant testified as CW1. He adopted his witness statement on oath dated 9th July 2019 and 5th October 2021 respectively, and tendered the following documents as exhibits. Exhibit FNU 1, 2, 3, 4, 6, 5, 6, 7, 8. Exhibit FNU 9, 10A, 10B, respectively. CW1 was cross-examined by the learned counsel for the defendant, and as there was no re-examination, claimant closed his case and the matter was adjourned for defense. The defendant on the 2nd of December 2021 opened his defense by calling his sole witness, Mr. Harry Ekun, DW1, who has adopted his witness statement on oath dated 30th September 2021. DW1 was cross-examined by the learned counsel for the claimant. As there was no re-examination, the case of the defendant was closed and the matter was adjourned for adoption of final written addresses. Defendant final written address. Defendant final written address is dated and filed on the 14th of December 2021, wherein 3 issues for determination were submitted to it. Number 1, whether the claimant has a cause of action against the defendant, and whether the claimant, the claim The defendant final written address is dated and filed on 14 December 2021, wherein 3 issues for determination were submitted to it. Number 1, whether the claimant has a cause of action against the defendant, and whether the claimant brought against the defendant, whether the claim brought against the defendant is not a statute barred, having been commenced against it more than 6 years after the cause of action was said to have arisen. Number B, what is the effect of the transfer of the claimant's employment to the Federal Mortgage Finance Limited? and whether the defendant can be held liable for the actions of the Federal Mortgage Finance Limited taken after the consensual transfer of the claimant's employment. Number C, whether the claimant has proved that the defendant acquired the asset and liability of the Federal Mortgage Finance Limited to have been entitled to have its name substituted for the Federal Mortgage Finance as a party to this suit and to answer for obligations clearly not engaged by it. Counsel the defendant submitted on issue 1 that it is trade law that he who asserts must prove the fact asserted, citing the case of Heritage Bank and Don Check Nigeria Limited. According to the defendant, there is nothing before the court that the Federal Mortgage Finance Limited transferred its asset or liabilities to the defendant, or that there was a merger. Counsel also submitted that the alleged breach of contract of employment by the wrongful termination of the claimant with Federal Mortgage Finance Limited, which is the cause of action, was instituted at Federal High Court between the claimant and the Federal Mortgage Finance Limited, and not the defendant. That the suit against the defendant before this court has been cut off by statute of limitation. That from the date on the complaint and settlement of facts, the cause of action arose upon the issuance of a letter dated 27th of October 1995, while the suit was instituted against the defendant on 29th of July 2019. Hence, same is cut off by statute of limitation, citing section 8(1) of the limitation law of Lagos State. Lana Counsel submitted on issue 2 that parties are bound by the terms of their contract, and none of them can unilaterally vary same without the consent of the other, citing Maidara and Halilu. That the claimant fully accepted his new employment with the Federal Mortgage Finance Limited and was deployed to his branch office pursuant to his new terms of employment. Hence, the employee and employer relationship between the claimant and the defendant ceased to exist. Counsel ceased to exist. Counsel submitted on issue 3 that on the authority of the cases of Mrs. U. Maduka Nigeria Limited and BPE, while substitution of parties to a case is not alien to the law and can be granted by the court even at the appellate stage, but the law permits this to be done only where there is a genuine case of death, bankruptcy, assignment, transmission, or devolution of interest or liability of a party to the suit. To the submission of a counsel that the above preconditions were not present in the instant case, as no credible evidence was adduced to prove merger, and it is strict law that a party who fails to adduce evidence in support of any amendment in his pleadings or claims is bound to fail, and such claims are deemed to be abandoned, citing Mobile Produce Nigeria Limited and Omenweke. Claimant's final written address. Claimant's final written address, which is dated and filed on 9th of March 2022, was deemed properly filed and served via leave of court. The final written address contains 3 issues for determination to it. Number 1, whether this action is barred by statute of limitation and the Honorable Court robbed of the required jurisdiction to entertain the suit. Number 2, whether the substitution of the Federal Mortgage Bank of Nigeria as a defendant in this suit is valid in law and makes it liable to the claims of the claimant. Number 3, whether on the state of the pleadings and evidence of the parties before this Honorable Court, the claimant has proved his case against the defendant and entitled to judgment. Ghana Council submitted on issue 1 that while a statute provides for the commencement of an action within a prescribed period in respect of course of action, according to the claimant, action commenced after the prescribed time will be statute barred, and the court will have no jurisdiction to entertain it, lying on the case of Bakari and Nigerian Railway Corporation. And the claimant demonstrated that his employment with the FMF Limited came to an end on 27th of October 1995. And from the record of the court, the claimant instituted this suit at the Federal High Court in 1999, that by the prohibition of Section 122 of the Evidence Act, the court is allowed to look at its record and take judicial notice of same. Counsel therefore submitted that the suit is not statute barred, and as it was instituted within the prescribed timeline provided by statute for the institution of employment cases or simple contract. Counsel submitted on issue 2 that by order 30/28, the rules of this honorable court, the substitution of the present defendant who took over the defunct FMF Limited is legally justified and valid, as the defendant is still in the eyes of law as the original party in the proceedings, relying on CBC and Nigeria Limited and Okoli. The counsel submitted on issue 3 that it is settled law that a claimant in the case of wrongful termination of employment has a duty to prove the terms and conditions of the said employment, citing Ibama and Shell Petroleum Development Limited. According to the claimant, he has in the instant case proved his terms of employment as shown in exhibit FNU 1, 2, and 3. Counsel submitted that on the issue of merger, TW1 testified that the defendant that the FMF Limited was liquidated and during cross-examination was unable to adduce evidence relating to the instrument of liquidation, the name of the liquidator, and the date of the liquidation. Counsel submitted that FMF Limited was not liquidated, but merged with FMBN, that the merger of incorporation as in the instance case is a matter of law, citing sections 122 and 123 of the Evidence Act. Defendants reply on points of law to the claimant's final written address. This is my decision. I've carefully perused the pleadings filed by the parties, the evidence adduced, and submission of the respective counsel. I note that parties in the instance case have formulated several issues for determination, but I will deal with the issues as the need and the relevance arise. However, the main point upon which I will decide this case is whether the claimant is entitled to the reliefs sought. Starting off with the preliminary points, the defendant in his notice of preliminary objection, which is incorporated in his final written address, has argued that the claimant's case is stale because while the cause of action arose in 1995 between the claimant and the Federal Mortgage Finance Limited, but the defendant's name was joined in the suit sometimes in 2019. And according to Section 8(1)(a) of the Limitation Law of Lagos State, actions founded on simple contract shall not be brought after the expiration of 6 years from the date of the cause of action, arose. It is settled law that a limitation law takes away the legal right of a litigant to enforce an action while the action is not instituted within a time frame enacted in the statute of limitation. Where an action is instituted outside the time so allotted by the statute, that action so instituted is statute barred and cannot be maintained since it involves the court and the timing same. In the case of INEC and Obadibo local government.
Okay.
Mr. Latif, Latif Apolavi.
Hello, sir.
Please, can you mute yourself?
Can I do what, sir?
Mute yourself. You are disturbing us.
Okay.
Somebody is interrupting the proceedings, please. Where an action is instituted outside the time so allotted by the statute, that action so instituted is statute barred and cannot be maintained since it robs the court of the jurisdiction to entertain and the timing same. See the case of INEC and Obadibo local government. It's also important to note that limitation law bars the action and not the cause of action. The sense of limitation law is that the legal right to enforce an action is not a perpetual right, but a right generally limited by statute. It becomes imperative to note that time begins to run for the purpose of limitation law from the date the cause of action accrues, and in determining whether an action is statute barred, claimant's complaint and a statement of fact are the determinant factors to ascertain the date the cause of action accrued and the date the action was commenced. It's clear from the statement of fact of the claimant that the cause of action accrued when the claimant's appointment was terminated in 1995. There is, however, a disagreement between the parties about the status of the defendant. While the defendant said that the Federal Mortgage Finance Limited is a distinct and separate entity from the defendant, but the claimant contended that the Federal Mortgage Finance Limited and the defendant have merged, and the defendant has assumed assets and liabilities of the Federal Mortgage Finance Limited. The provision of Order 13 Rule 28, Sub-Rule 1 of the rules of this honorable court will fit into the instant issue. It is stated as follows, and I quote: where by reason of death or bankruptcy or any other event occurring after the commencement of a proceeding and causing a change or transmission of interest or liability, or by reason of any person interested coming into existence after the commencement of the proceeding, it becomes necessary or desirable that any person not already a party, or that any person already a party should be made a party in another capacity, in order that the proceedings shall be carried on between the continuing parties, and such new party or parties may be obtained upon application for such change or transmission of interest or liability of any such person interested having come into existence. Unquote. Going by above, therefore, I hold the view that the substitution of the Federal Mortgage Finance Limited to the defendant by an order of the court made on the 17th of June 2019 does not translate to the action being statute barred. The defendant is deemed to be the original party in the proceedings. It follows, therefore, that the contention of the defendant that this matter is statute barred is untenable and is hereby discountenanced. Consequently, the NPO is overruled and is hereby dismissed. Let me also turn to the defendant's application to set aside the order for payment of costs. From the record of the court, the order for payment of costs was awarded on the 4th of October 2021, but the motion to set aside the said order was filed on the 1st of December 2021, about 3 months after the grant of the order. Order 38 Rule 6.4 and Rule 24.2 of the rules of this honorable court state that an application to set aside or review a court order shall be made within 14 days from the date of the order. It is clear in the instant case that the time limit within which the defendant shall set aside the court order had expired, and having the prescribed period of 14 days to review the court order expired, the defendant applicant must apply for extension of time within which to make the application, no matter how strong its reasons appear. In the present circumstance, it is the extension of time that will give this court the jurisdiction to hear and determine the merit of the application. There was no such application before me that should have conferred on me the jurisdiction to hear the application, much less to talk of judicious exercise of my discretion. Extension of time to review a court order is not an incidental order that the court can make under the omnibus prayer. It must be specifically prayed for and granted. The provision of Order 38 Rules 6 Sub-Rule 3 and Rule 24 Sub-Rule 2 Supra must be complied with before the defendant applicant begins to move the cause to be heard on merit. And in the present case, the applicant's failure to apply for extension of time was fatal to his application. Hence, his application is incompetent. Accordingly, defendant's application to set aside the award of 100,000 Naira cost dated 30th November 2022, but filed on the 1st of December 2022, is hereby struck out. See the case of the Supreme Court of the Supreme Court case of Sanusi and Ayula. Coming to the substantive matter, it is the claimant's case that he joined the service of the defendant company in 1977 at the age of 33 years, and with the deconsolidation of the defendant in 1993, he was deployed to Federal Mortgage Finance Limited. That by his transfer, his service with the defendant was treated as continuous with his subsequent service with the FMF Limited. That however, the Federal Mortgage Finance Limited is now defunct and has been taken over by the defendant. Claimant further said that he was prematurely and unjustly retired at the age of 51 years instead of 60 years after serving the defendant for 18 years. It is contended by the claimant that the federal government of Nigeria in September 2000 merged the Federal Mortgage Finance Limited with the Federal Mortgage Bank of Nigeria. And as a result of that merger, all assets and liabilities of the Federal Mortgage Finance have been taken over by the defendant, and the legal personality of the Federal Mortgage Finance was subsumed in the defendant. The defendant on his part denied that the Federal Mortgage Finance Limited was merged or rejoined with its parent company, but only stated that the Federal Mortgage Finance Limited is liquidated for years. Claimant in his final written address contained that the merger of the defendant with the Federal Mortgage Finance Limited is a matter of law, which the court can take judicial notice of under Section 122 of the Evidence Act. Also refer the court to the Google search on the issue of merger. I visited the Google search and found this statement as follows, and I quote: "The federal government has merged the Federal Mortgage Finance Limited, FMFL, and the Federal Mortgage Bank of Nigeria, FMBN, with a view to revitalizing the mortgage industry and provide affordable housing low-income earners," unquote. In the absence of any contrary evidence, I wish to go by this statement and hold the view that since there is no contrary evidence from the side of the defendant, and the fact that the defendant is an agency of the federal government whose action the court can take judicial notice of, then this shows that there was a merger between the defendant and the Federal Mortgage Finance Limited. And once there is an issue of merger, then the asset and liabilities of the defunct company will be deemed to have been taken over by the other company. Now, the claimant has asked for 6 reliefs. His first 2 declaratory reliefs are that he's entitled to remain in the office for up to 35 years or to attain the age of 60 years, and that his purported retirement at the age of 51 years is wrongful and of no effect. The claimant has argued that he has discharged the burden on him to prove his case by tendering in evidence his letter of employment and a staff handbook, among others. It appears from Exhibit FNU that the defendant's condition of service, that is the defendant's condition of service, the defendant is a creation of statute. And while a contract of service is governed by the provision of statute, while the condition of service are contained in regulation derived from statutory provision, they invest the employee with a legal statute higher than the ordinary one of master and servant. They accordingly have statutory flavor. See the case of Omo, Lome, and Waek, where an office or employment has a statutory flavor in the sense that its conditions of service are provided for and protected by statute or regulations made thereunder. Any person holding that office or in that employment enjoys a special status over and above the ordinary master and servant relationship. In the matter of discipline of such person, the procedure laid down by the applicable statute or regulations must be fully complied with, and if materially contravened, any decision affecting the right or tenure of office of that person may be declared null and void. See the case of Asisanya and Afri Bank Limited. It was held in Idigbe and FPSC that the civil service rules of the Federal Republic of Nigeria, or of the civil service rules of the Federal Public Service, which govern conditions of service of the Federal Public Servant, made pursuant to the then 1963 Constitution, have constitutional force, and they invest the public servant over whom they prevail a legal status beyond the ordinary or mere servant, master and servant relationship. In Nepal and Ango, it was held that the employer of an employee with statutory flavor has no right to terminate his appointment at will, because the employee does not hold the appointment at pleasure of such an employer. In other words, to terminate such an appointment, the employer is duty bound to comply with the conditions previously laid down in the condition of appointment, failing which such termination will be held to be ineffectual and void. However, I need to underscore the point that the fact that an employer is a statutory body does not elevate all its employees with status of employees with statutory protection, or that the condition of service of its employees must be of a special character, ruling out the relationship of master and servant relationship. The court must confine itself to the terms of contract of service between the parties, which provide for their rights and obligations. In the instance case, Exhibit FNU 1, claimant's appointment letter must be taken into consideration. See the case of Fakwadi and OAU THC. It is also essential to state that a question whether a contract of employment is governed by statute or not depends on the construction of the contract itself or of the relevant statute. See the case of Oloru Tumba Oju and Abdurrahim. In Fakwadi's case, Supra, the plaintiff was a nurse in the employment of the defendant. She was employed in 1976, and a letter of employment was tendered as an exhibit. She says she received a query from the defendant accusing her of a missing stainless steel ball and was asked to state all she knew about the missing ball. All of a sudden, she received a letter of termination of her appointment on the 13th of November 1987. She says she was shocked to have received the termination letter because she felt she had not committed any offense. The defendant, on the other hand, admitted terminating the appointment of the plaintiff, but said that it was not as a result of the query concerning the missing of the stainless steel ball, nor for any misconduct on the part of the plaintiff. Rather, it was as a result of retrenchment exercise it found necessary in order to cut down overhead costs. It can be observed in Fakwadi's case that the plaintiff was not terminated as a result of misconduct or commission of any offense, where disciplinary procedure will have necessarily been followed before termination of appointment. I wish to stress that parties to a contract of employment are bound by the terms and conditions of their employment. In the instance case, claimant's letter of appointment Exhibit 1 provides for the mode of terminating the appointment in paragraph 5, which says thus, and I quote, during the period of probation, this appointment can be determined by either side, giving 1 month's notice or a month's salary in lieu of notice thereof. While after confirmation, a notice of 3 months or payment of leave will be required on either side, unquote. It follows from the above that the claimant appointment with the defendant is a contract of service terminable by either party by giving 3 months notice or 3 months salary in lieu of notice. In view of the fact that the termination of the appointment of the claimant was not based on any misconduct or infraction, the defendant is at liberty to terminate the appointment in accordance with the laid down in accordance with the terms laid down in the letter of appointment, which is stated that 3 months notice or 3 months salary in lieu of notice must be given on either side. It's my view that the 3 months notice or 3 months salary in lieu of notice would be a valid termination of the claimant's appointment. Hence, where the contract of employment is determinable by the agreement of the parties, as in the instance case, there is no question of the contract having a statutory flavor. The fact that the other party is a creation of statute does not matter. Here, I also agree with the defendant counsel that since the appointment was not terminated on ground of misconduct, then the issue of fair hearing does not arise. In view of the content of Exhibit FNU1, it is obvious that the claimant's appointment is not protected by a statute, and in such case, the claimant can be validly terminated by the defendant by giving 3 months notice or 3 months salary in lieu of notice. Claimant's appointment was terminated via Exhibit FNU 7, the part of which states as follows, and I quote, "Would like to inform you that the company has decided to dispense with your services as they are no longer required. Accordingly, you are hereby retired from the service of the company with immediate effect, and with full benefits, you are also to be paid 3 months salary in lieu of notice," unquote. It appears that the termination of the appointment of the claimant is in line with Exhibit FNU1. Therefore, the declaration sought by the claimant that is entitled to remain in the employment until he has served for 35 years or attained the age of 60 years, and that his termination is wrongful and not grantable. The reason being that if a termination or dismissal of employment is wrongful, the remedy is in damages as regards his salary and other entitlement at the time of the termination or dismissal, and the employment cannot be treated as subsisting. See the case of Osisanya and Afribank. It is also the law that termination, even if wrongful, bring to an end the contract of service owing to the confidential relationship between master and servant, which cannot continue in the absence of mutuality. See the case of EFETA and SPDC Nigeria Limited. General law is that courts will not grant specific performance of a contract of service, and therefore a declaration for reinstatement will rarely be made. For that declaration to be granted, special circumstances will be required, and such special circumstances have been held to arise while the contract of employment has a legal or statutory flavor, thus putting it over and above the ordinary master and servant relationship or a special legal status, such as a tenure of public officers is attached to the contract of employment. See the case of Idoniboye and NNPC, Festus, and Police Service Commission. It is clear from the set of pleadings that the employment relationship between the claimant and the defendant was regulated by Exhibit FNU1 and FNU6, and the termination of the appointment was in line with the same exhibit and does not therefore constitute a breach of the contract of service. Consequent upon the above findings and the reasoning stated so far, I'm of the opinion that the claims of the claimant in his reliefs A, B, C, E, and F fail. Hence, I will make the following orders: that the termination of the appointment of the claimant by the defendant was not wrongful, having complied with the requisite 3 months salary in lieu of notice to the claimant in accordance with Exhibit FNU1. The defendant shall compute and pay the claimant his 3 months salary in lieu of notice and his terminal benefits for the 18 years period he had worked for the defendant from 1977 to 1995. That the failure of the defendant to compute and pay the said entitlement within 30 days shall attract 10% interest per annum until it is fully liquidated. Yes, Mr. Sisi,
Yes, my Lord, we commend your Lordship for that well-considered judgment. We are grateful for the industry that was put into it. We are grateful, sir.
Thank you, Mr. Mauke. They right from the word go, the council should have looked at the employment letter, the terms of the contract. This case was filed in
Yes, my Lord.
It was filed in 1999 at the Federal High Court. 1999, and transferred to this court in 2013. So it has been there for more than
Very well, sir.
Yes, for 25 years. 25 years. Is Akumute.
My Lord, we are most grateful for the sound judgments of the courts who comply as stated.
Okay, thank you. So I don't know whether the council in this case and Minnesota Nigeria Limited, that is Mr. Samuel Quadri and Ngobodo.
Yes, sir. We are here, sir.
You are here?
Yes, sir. Counsel to
Yes.
the defendants.
Okay, what about the counsel to the claimant, Teresa Obiamaka Mba? Is Samuel Quadri? Yes.
My Lord, I'm here, sir.
Okay, are you here?
Good morning.
Yeah, okay.
I'm here, my Lord.
Okay, so can I take your appearance?
My Lord, the suit number.
Respectfully, my Lord.
NICN stroke LA stroke 75 stroke 2020.
Okay, my Lord.
Okay, that Haja.
Good afternoon, sir.
Thank you. You're welcome. So yes, counsel for the
claimants, my Lord.
yes.
M.E. Odumomi.
M.E.
Odumomi, my Lord. O-D-U-N-M-O-M-I.
O-D-U-N.
Yes, my Lord. M-O-M-I.
M-I.
O-D-U-N-M-O-M-I.
Okay, Mommy, yes. For the
claimant.
Claimants, my Lord.
Okay, so yes, counsel for the defendant.
Respectfully, your lordship. I.O.
Yes.
Abubakar.
I.O.
Abubakar.
Yes, you are alone?
Yes, for the defendants. Okay.
So this is my judgment. This is a case commenced by the claimant by of complaint and other initiation processes filed on 25th of February 2020, where the claimant asked for the following reliefs as contained in the statement of fact against the defendant. Number one, a declaration that the claimant is entitled to be paid a sum of 7,783,426 naira, 86 kobo, being the entitlement or gratuity of the claimant owed her by the defendant. Number two, a declaration that the refusal and or failure of the defendant to pay the claimant as entitlement and gratuity is wrongful and in breach of the first defendant's employee's contract handbook. Number three, an order directing the defendant to pay the claimant the sum of 7,783,426 naira, 86 kobo, with the entitlement and gratuity due to her, and which the defendants have neglected, failed, and refused to pay her. Number four, an order directing the defendant jointly and severally to pay the claimant the sum of 6 million naira only as damages for the untold hardship, loss, pain, distress, emotional and psychological trauma which the claimant has been subjected to by the defendant acts of wrongfully withholding the final entitlements to gratuity of the claimant. Number five, an order directing the defendant to pay the claimant 21% interest on the above sum of 6 million naira after judgment until the judgment sum is fully liquidated. Number six, the sum of 500,000 naira only as cost of the action. The defendant did not file any process in response to the claimant's suit, but were represented by counsel. Case of the claimant. From the pleading filed by the claimant and her testimony, he was employed by the first defendant as a secretary to the technical sales and marketing manager on 2nd May 1980. She eventually rose to the position of human resource industrial relations coordinator in 1998 and retired in September 2015 after 35 years of service of the defendant. It was survived by a letter dated 13 January 2016 that the defendant informed ICO Insurance PLC of the retirement of the claimant and demand for a check of the contribution made by the claimant, which the defendant regularly deducted from her salaries. But the defendant only remitted the purported deductions thrice between 2006 to 2015. According to the claimant, she continued working with the defendant till 2016 because her entitlement was not paid. The defendant informed the claimant of the breakdown of her final entitlement via a letter dated 18 November 2016, but failed to pay her. That the claimant, after her retirement, was offered and accepted a temporary appointment by the defendant on a contract basis while waiting for the payment of her entitlement. At the end of the temporary employment in December 2017, the defendant still refused to pay the claimant her entitlements to gratuity, despite several efforts made to recover same, which all proved abortive. Trial in this matter commenced on 29th of June 2021, while the claimant testified as CW1. She adopted her witness statement on oath, dated on 5th February 2020, and tendered the following documents as exhibits. Exhibit TOM1, TOM2, TOM3, TOM4A and B, TOM5, TOM6, TOM7, 8, TOM9A to E, and TOM10. Claimant was thereafter cross-examined by learned counsel to the defendant, and as there was no re-examination, claimant's case was closed. As the defendant did not file any statement of defense, the matter was adjourned for adoption of final written addresses. Claimant's final written address, which was filed by counsel on the 3rd of November 2021, contains one issue for determination to it. And I quote, whether having regard to the facts and circumstances of this case, the claimant has successfully proven that she is entitled to the relief sought in this suit. Counsel submitted that it is a fundamental principle of law that averments in the parties' pleadings, which are not controverted by the adverse party, are deemed admitted. Such in the case of Akudo and Guinness PLC. That it is true a statement of defense that the averment in the claimant's statement of fact can be controverted. Claimant therefore said that due to the failure of the or refusal of the defendant to file a defense to this suit, the defendant are in law deemed to have admitted all the content of the claimant's pleadings. The other counsel submitted that to improve the claimant's claim, the claimant had adduced cogent and credible evidence and tendered documents as exhibit in support of her claims, which are not objected by the defendant, and adopted her statement on oath as evidence. That the claimant gave evidence under examination in chief that she was employed via a letter of employment, which was not controverted. The claimant further stated in evidence that she is entitled to the sum of 7,783,426 naira 86 kobo, as computed on evidence in exhibit TOM 4A and B. The claimant under cross-examination stated that the basis for her said sum was because she was employed by the company and worked hard for the sales sum as computed, and the defendant failed to pay her entitlement, which is unchallenged and uncontroverted. The submission of counsel that the claimant made several demands for entitlement from the defendant, which was not responded to, except a response from one engineer H.C. Omo, who told her to be patient with the first defendant, yes, nothing was eventually done. According to the claimant, the second defendant, being the managing director of the first defendant, was in a position to influence the decision of the first defendant in the payment of the claimant's entitlement, but did nothing, and this fact was not challenged by the defendant, citing section 20 and 123 of the Evidence Act. Defendant's final written address. Defendant's final written address filed on 24th of March 2022 was deemed properly filed and served by leave of court on 28th March 2022, wherein one issue for determination was submitted to it. And I quote, whether having regard to the evidence before this honorable court, the claimant has satisfactorily made out a case to be entitled to the reliefs sought. Counsel to the defendant submitted that the right to file final written address is a constitutional right of every party in any judicial proceeding, and the same ignores the party even when he did not file pleadings, such in the case of Sterling Bank and Oyoyo. It was further submitted that the relief sought by the claimant in the instance case are for certain declaration and orders, and the law is clear that a party seeking declaratory relief must prove his case by cogent and verifiable evidence. But the position of the law is that even where the defendant admits the claim, the court should refrain from granting some except it is satisfied through proof by cogent evidence proffered by the claimant. Referring to the case of Arepe Sola and Ongilola, Eguin, and Onoa. The counsel argues that generally a contract of employment spells out the terms of the contract of employment, such as the salary, working hours, leave, allowances, gratuity, pension, insurance, and certainty of terms is the hallmark of a written contract of employment, as in the instance case, which should not leave the court in doubt as to the exact terms of the contract of employment between the parties. The law is that the claimant must spell out in the statement of fact the essential terms of the contract of employment and not to leave the terms to speculation by the trial court. Such in the case of ASCA, Bitumen Company, and ISA. It is the argument of counsel that in order to establish her entitlement, the claimant is required to give detailed particulars of her employment with the first defendant by exhibiting the terms of the contract of employment or the terms of her last promotion letter to establish her entitlement to the claims made in this case. That the claimant in the instance case did not tender her contract of employment or her last promotion letter with the first defendant to show the basis of her claims. Such in the case of Emenitel Limited and Oleka, Adekule and UBA. It was further argued that the court does not render justice based on speculation. Such in the case of Maikiri and Yahya. It was contended by the defendant that Exhibit TO M3 and 4, A and B, which were authored by the claimant and addressed to herself, cannot be taken to be authorized by the first defendant. Another counsel also contended that, notwithstanding the position held by the claimant in the first defendant, documents that were meant to be for the benefit of the claimant were signed by any of the directors of the first defendant, as in Exhibit TO M1. It is tried principle of law that a man cannot be a judge in his own case. Nemo judex in causa sua, citing Graba University of Maiduguri. To the further contention of the defendant that there was no credible evidence of any authentication put before this honorable court to show that Exhibit TO M4B, the purported computation of the claimant gratuity, was computed by the accounts finance department of the first defendant as alleged by the claimant. It is without equivocation that an unsigned document is a worthless piece of paper that is akin to an animal that has been drained of its blood, referring to the case of Omega Bank PLC and OBC Limited. It is counsel submission that the claimant has not shown any scintilla of evidence that it was part of her duties to author and sign documents meant for herself in order to justify why she authored exhibits TOM, A, and B. It was argued that the claimant averred that she retired from the employment of the first defendant in 2015, but exhibit TOM 4A, which is dated 18 November 2016, a lot longer after her retirement, was authored by the claimant and addressed to herself. Another counsel finally submitted that the law is well settled in a plethora of authorities, that the court does not make a case for a party, and that the claimant succeeds on the strength of his own case. Claimant's reply on points of law to the defendant's final written address. It is the claimant's argument that the sole issue for termination in the instance case is whether the claimant is entitled to her claims before this honorable court, considering the express tender. Counsel referred to Section 10 of the Evidence Act and stated that the defendant has not denied being indebted to the claimant in respect of her gratuity, but are only concerned with the computation of her entitlement. There is no provision in the Human Resource Policy and Employment Manual of the first defendant that is stated that the computation of gratuity must be or must not be signed by a particular person. That's in the case of Broadbank and Olaying Ola. The other counsel stated that the claimant has averred in the claim that a contract of employment was lost in the course of relocation and therefore got a letter of indemnity to that effect, which was not controverted by the defendant and is therefore deemed admitted. Like in the case of Okodu and Guinness Nigerian PLC. Counsel also stated that the documents exhibits TOM 3 and 4 being authored by the claimant do not mean. Counsel also stated that the documents being authored by the claimant does not mean that they did not emanate from the first defendant, as is clearly shown on the letterhead of the first defendant. And for the fact that there was no evidence laid by the defendant to dispute that fact. But the claimant under cross-examination stated that she authored those documents in a capacity as the HR, and this fact was not disputed too. Claimant argued further that there is no provision in the defendant's employment manual that provides that the HR cannot sign documents meant for our benefit. Counsel referred to page 10 of the first defendant handbook that former staff who left the company's service with good record could be re-engaged, and the claimant was duly re-engaged by the first defendant until when she eventually left. It is the argument of counsel that once a document is pleaded, tendered, and admitted at trial, making use of same by the court does not depend on the party ordering the court to do so. That's in the case of Akpan and Federal Mortgage Finance Limited. Claimant finally referred to page 50 of the defendant's handbook, which vividly describes the conditions of work of the employee of the first defendant and defines what the gratuity of the company's employees is about, and all the claims made by the claimant are covered by the provision of the said handbook. Counsel referred to the case of NNPC and Komolafe and section 173 of the Constitution of the Federal Republic of Nigeria. My careful perusal of the pleading filed by the claimant, the evidence adduced, and submission of the respective counsel for the parties appear to show that the claimant was employed by the first defendant in 1980 and rose to the position of Human Resources and Industrial Relations Coordinator and retired after 35 years of service with the defendant, but was not paid an entitlement to gratuity. Claimant therefore asked for some declaratory reliefs and orders. So basically, it's a case for non-payment of the claimant's terminal benefits. I note that parties have in their respective written addresses formulated one issue each for determination, which are all suitable, but I have chosen to adopt the issue submitted by the defendant because it is shorter. The issue states thus, and I quote, without having regard to the evidence before the court, the claimant satisfactorily made out a case to be entitled to the reliefs sought. To be entitled to the relief sought, the claimant bears the burden to prove the existence and non-existence of the fact he has asserted, as he would fail if no evidence is adduced in his favor. See sections 131, 132, and 133 of the Evidence Act, and the case of Aminu and Hassan. I note that the defendant did not file any defense, but generally, where evidence is uncontradicted, the onus of proof is satisfied or minimal proof, since there is nothing on the other side of the scale. However, the failure on the other part of the defendant to give evidence does not exonerate the claimants from proving their case, though minimally. See the case of Lamy and Data Processing Maintenance Services Limited. The defendant, having not filed any defense, will be deemed to have admitted the claimant's claims in the statement of fact. This is based on the principle that where a defendant disputes the plaintiff's claims or a case, he must file a statement of defense and lead evidence thereon at the trial. See the case of Ege Shipping and Trading Inco and Tigris International Corporation, Adeyinka and Eli Rozek. In Emodi and Emodi, Honorable Justice Akeju, JCA, had this to say, and I quote, where therefore a plaintiff files his statement of claim, is an allegation of fact against the defendants or one of them, such defendants or defendant who do or does not admit the truth of the allegation must file a defense to contradict, controvert, challenge, or deny the allegation. Where no defense is filed, the defendant is deemed to have admitted the assertion and the court may preemptorily enter judgment against the defendant. In a case where the defendant files no defense, the standard of proof cast on the plaintiff is a minimal one. See the case of Khalid, Bakara, Chami, and UBA. The defendant, however, have in the final written address stated that the claimant in the instance case did not tender her contract of employment or her last promotion letter with the first defendant to show the basis of her claims. It was also contended by the defendant that Exhibit TOM3 and TOM4A and B, which are authored by the claimant and addressed to herself, cannot be said to have been authorized by the first defendant. The claimant in her pleading and evidence stated that her employment letter was lost, but she was given Exhibit TOM1 instead. She also stated under cross-examination that she authored and signed Exhibit TOM4A and 4A on behalf of the defendant, that she signed Exhibit TOM4A and B in her capacity as the Human Resources Coordinator of the first defendant, and they were short of staff at that time. That the account department of the first defendant computed Exhibit TOM4A. I expected that the defendant would have filed pleading to controvert and challenge the evidence adduced by the claimant, but they rather chose to controvert that in their final written address. Although addresses are designed to assist the court in readily ascertaining the material and relevant points arising in the case and the applicable law to the issues in order to enable it arrive as a just decision, but final written addresses, no matter how brilliant and alluring, cannot form or be valued as evidence, nor can they replace the status of evidence in the proceedings. Cases are determined on cogent and credible evidence, and not the advocacy or brilliance of counsel, as expounded in an address, which is but a poor substitute for properly adduced evidence before a trial court. See the case of Oniga Oga and Chief Linus Ocon. I found that the fact of the claimant's case are straightforward and uncontested. Hence, it only requires minimal proof. The fact that the claimant was an employee of the defendant and had worked for 35 years is not in dispute. This is evidenced by Exhibit TOM1. The terms and conditions of the service of the employment and the payment of gratuity are also contained in Exhibit TOM2. And the breakdown of the claimant gratuity was clearly stated in Exhibit TOM4A and B. Based on the foregoing, the claimant is therefore entitled to a gratuity as stipulated in Clause 28.1 at page 50 of the Human Resource Policy and Employment Manual, Exhibit TOM2. The claimant's case therefore succeeds, and I accordingly make the following declaration and orders. Number one, a declaration that the refusal and or failure of the first defendant to pay the claimant her entitlements to gratuity is wrongful and in breach of the first defendant Human Resource Policy and Employment Manual. Number two, a declaration that the claimant is entitled to be paid the sum of 7,783,426 naira 86 kobo, being her entitlements to gratuity owed her by the first defendant. By the first defendant. Number three, the first defendant is directed to pay the claimant the sum of 7,783,426 naira 86 kobo, being the entitlements to gratuity due to her. The reliefs for damages and 10% interest are hereby declined. Rather, the judgment shall attract 10% simple interest until judgment sums are fully liquidated. 200,000 naira court is awarded in favor of the claimant against the first defendant.
As court pleases, my
As the
lord.
court pleases, my lord.
Yes. Please.
We're most grateful, your lordship.
My Lord, we appreciate the industry of the court in delivering this judgment. We're most grateful.
Thank you, Mommy.
We're
Yes,
most grateful,
sir.
your lordship. We appreciate the
Thank you,
industry.
Mr. Opa.
Yes, sir.
Thank you. Aja. Aja.
Yes. Yes, my lord.
Let's get to NIC instruct LA 63/2020.
Okay, my lord.
Akinrinade.
Akinade. Yes, Miss Dero Daniel is online.
Akinrinade.
63.
Good morning, my lord.
Yes.
Oh, good afternoon, my lord. I'm sorry. I know I saw the Claimant Council. I don't know if I saw the
Good
Claimant
afternoon, my lord.
Council.
Yeah, the Claimant Council is here.
All right.
Chidozi?
Yes, my lord.
Chidozi Uzolu.
Uzolu.
May I please?
So Chidozi.
Chidozie Uzolu, my lord.
Yes, Uzolu. For the claimant. Yes. Dero? Is that
Yes,
Dero?
my lord. Yes, my lord. Good afternoon, my lord. Daniel also. Yes, my lord. Also appearing with me, my lord, is John Agbonika for the defendant. I'm most grateful, my lord.
Okay.
May it please, my lord. We also have I have some colleagues appearing with me as well.
Okay. Yes, Mr.
Ikenna Only.
Ikenna.
Only. ONWU.
ONWU.
NLI.
NLI.
Yes, my lord.
Okay.
And Rukayat. Only.
Yes.
NLI. And Rukayat Ambali.
Rukayat Ambali.
Yes.
Rukayat Ambali.
As copied.
So this is my judgment. The claimant commenced this suit by way of complaint and other complaint processes filed on the 19th of February 2020 and asked for the following reliefs as contained in the statement of fact against the defendant. Number one, a declaration that the act of the defendant suspending the claimant indefinitely without pay is unlawful, not being provided for in the contract of employment between the defendant and the claimant. Number two, a declaration that the willful deduction of the sum of 45,000 naira from the salary of the claimant for the period of September 2015 to May 2016, respectively, by the defendant without claimant's consent is unlawful. Number three, the sum of 79,677 naira 42 kobo in the claimant prorated salary for the remainder part of the month of August 2019. Number four, the sum of 753,563 naira net of tax being the claimant's salary for the period of September to December 2019 at the rate of 190,000 naira less tax per month. Number five, the claimant prorated salary from the 1st of January 2020 up until the date of judgment in this matter, or up until the claimant's contract of employment is properly terminated, whichever is earlier. Number six, the claimant's bonus tied to the defendant's financial performance every month in the sum of 48,000 naira from August 2019 up until the date of judgment in this matter, or up until the claimant's contract of employment is properly terminated, whichever is earlier. Number seven, a refrigerator of the same type was given to all employees of the 5 years and above in December 2019, with the claimants entitled to as provided for in clause 35 of the defendant employee handbook. Number eight, the sum of daily meal provided to all employees of the claimant's grade in the defendant for each working day commencing from the 20th of August 2019 up until the date of the judgment in this matter, or up until the claimant's contract of employment is properly terminated, whichever is earlier. Number nine, claimant's Christmas entitlement for the year 2019 of the same type that was given to all employees of his grade in the defendant. Number 10, the sum of 405,000 naira being the total sum illegally deducted from the claimant's salary, rather the claimant's consent, from September 2015 to May 2016 at the rate of 45,000 naira per month. Number 11, the sum of 5 million naira being general damages for the emotional and financial hardship the claimant has been experiencing because of the defendant's unlawful act of suspending him without pay. Number 12, an order directing the defendant to pay the claimant's statutory pension contribution for the month of December 2014 and from the period between September 2015 to August 2019, and the outstanding pension contribution with the defendant failed to remit for the period between January 2015 to August 2015 into the claimant's retirement savings account, with Stanbic IBTC retirement savings account being the claimant's pension fund administrator. Number 13, interest on all the accrued sum at the rate of 21% till the date of judgment in this case, at the rate of 21% till the judgment is finally liquidated. Number 14, the cost of 350,000 naira only as cost of the action. So the defendant having been served with the claimant initiation processes entered appearance and filed a statement of defense on the 7th of July 2020 via an order of court for extension of time to that effect. Case of the claimant. See the case of the claimant from his pleading and evidence filed that he was employed by the defendant as his chief security officer by a letter dated 19th November 2014 and was confirmed by another letter dated on 3rd June 2015. According to the claimant, sometime in July 2019, he was instructed by the chairman of the defendant to recover a bus belonging to the defendant, which was impounded by the Lagos State Traffic Management, LASMA. Claimant averred that while he was preparing to take his breakfast and medicine, the chair of the defendant sent for him and instructed him to accompany her to LASMA's office to recover the impounded bus. But he requested for a few minutes from the chair lady to enable him have his breakfast and take his medicine. However, the chair lady, unknown to the claimant, had already left for the LASMA's office before he was done with his breakfast. It was averred that following the above incident, he was issued a query for alleged insubordination, which he immediately responded to. That he was thereafter issued a strong warning letter and subsequently a letter of indefinite suspension without pay, pending a decision to be made by the management which the defendant has failed to communicate to the claimant. It was further averred that the defendant has failed to remit the claimant's pension contribution to his retirement savings account for some certain period of time. Claimant also stated that the defendant between September 2015 to May 2016, without his consent, deducted from his salary the sum of 405,000 naira. Case of the defendant. For the defendant, the claimant was queried because he failed and or neglected to carry out the instruction of the chair lady to accompany her to LASMA's office 2 hours after the said instruction was given. The defendant was not satisfied with the response of the claimant to the query, and he was therefore given a strong warning letter and advised to write an apology letter to the chair lady. But upon his failure to deliver the said apology letter as requested, the claimant was issued a letter of indefinite suspension. It was stated by the defendant that it did not inform the claimant of his decision following his suspension because the claimant had already taken on further averred that in August 2015, they were in financial distress and were unable to fully meet the obligation of staff, business partners, and welfare providers. As a result of this, therefore, by various resolutions in one of the meetings in September 2015, when the claimant was in attendance, they had to reduce staff salary for managers and above by 25% and temporarily suspend the reduction of pension contributions for all staff salary. But based on this, the claimant's salary was reduced by 25%, but was restored to its original gross salary in June 2016. That the claimant at all times was in attendance and was aware of all the deliberation and resolution taken, but never objected to it in any way. The defendant admitted paragraph 12 of the claimant's statement of fact that he did not remit his pension contribution, but stated that it is still in the process of computing the claimant's outstanding pension contribution for onward remittance to the claimant's Stanbic IBTC RSA account. The defendant contended that the claimant's suspension was lawful and the bonuses and daily meal or sum are paid to staff based solely on the discretion of the management, and they're not provided for under the terms of employment of all employees handbook. The claimant is not at all entitled to any refrigerator, as it was given only to employees in active service as of December 2019 and did not include those on suspension. Trial commenced in the instance case on the 2nd of June 2021, where the claimant testified as CW1. He adopted a statement on oath dated 19th February 2020 and tendered the following exhibits. Exhibit AA1, AA2, AA3, AA4, AA5, AA6, AA7, 8, AA9, AA10, 11, and 12, respectively. Claimant was cross-examined and then discharged and closed his case as there was no re-examination. The defendant in his defense called one witness, Patrick Apu, DW1, who adopted a statement on oath dated 13 July 2020 and tendered the following exhibit. Exhibit OH1, OH2, 3, 4, OH5, OH6, 7, and OH8 respectively. DW1 was cross-examined by the claimant's counsel and later discharged after re-examination. The matter was then adjourned for adoption of further written addresses. So let me just skip the submissions. Defendant final addresses is there. Then claimant final address. So let me just get to my opinion. I've carefully considered the pleadings and evidence as presented by the parties, having also considered submission of the respective counsel for the parties and the issues raised. I know that the claimant raised 2 issues for determination, but I will take and adopt the issue submitted by the defendant as it is broader and all-encompassing. The issue is whether, having regards to the evidence laid at trial, the claimant has made out a case to be entitled to the relief sought in this suit against the defendant on court. The claimant's grievance is that he was given a query by the defendant, which he answered. And when the defendant felt dissatisfied, they gave him a strong warning letter and subsequently a letter of indefinite suspension without pay, that his salary was deducted by the defendant for some certain month without his consent. And the defendant also failed to remit his pension contribution to his retirement savings account. Let me quickly address the issue of failure to remit the claimant's pension contributions. The claimant's prayer is to direct the defendant to pay his statutory pension contribution for the month of December 2014, and from the period between September 2015 to August 2019, and the outstanding pension contribution which the defendant failed to remit for the period between January 2015 to August 2015 into the claimant's retirement savings account. I wish to take note that the defendant in paragraph 10 of the statement of defense has admitted paragraph 12 of the claimant's statement of fact that he did not remit his pension contribution, but stated that it is still in the process of computing the claimant's outstanding pension contribution for onward remittance to the claimant's Stanbic IBTC retirement savings account. It is the law that where a fact in the statement of fact is admitted in the statement of defense, either because it is expressly or impliedly admitted, it seems to be in controversy between the parties, and no evidence is required to prove such fact. In other words, there is no dispute on a fact that is admitted. See the case of Onobru Kerry and Esegine, Malik and Kadru Furniture and Carpets Limited. See also section 20 of the Evidence Act. Therefore, in light of the admission of the defendant in his statement of defense that did not remit the claimant's pension contributions, Rule 12 of the statement of fact ought to be granted, and I so order, to the extent that the claimant under cross-examination admitted that the defendant did not deduct pension contribution from his salary from September 2015 to August 2019. Claimant in Relief 2 has again asked for a declaration that the reduction of his salary by the defendant was unlawful. The defendant in his defense contended that the reduction was with the consent of the claimant. It tendered extract of minutes of meetings. It tendered extract of minutes of various meetings, exhibit OH6, to show that the reduction was with the consent of the claimant. I wish to state that the extract of meetings that do not have signature of the claimant cannot be said to represent the opinion and instance of the claimant with regards to what had transpired at the said meetings. Exhibit OH6 does not indicate that there was consensus of all those that have attended the meeting about the things that were discussed at the meeting. I think there should be an express consent of the claimants present at the meeting and he did not object. See Section 5 of the Labour Act, which is stated as follows. Number 1, except where it's expressly permitted by this act or any other law, no employer shall make any deduction or make any agreement or contract with a worker for any reduction from the wages to be paid by the employer to the worker, or for any payment to the employer by the worker, or for all respect of any fines, provided that with the prior consent and writing of an authorized labor officer, a reasonable deduction may be made in respect of injury or loss caused to the employer by the willful misconduct or neglect of the worker. Number 2, an employer may, with the consent of the worker, make deductions from the wages of the worker and pay to the appropriate person any contributions to provident or pension funds or other schemes agreed to by the worker and approved by the state authority. Number 3, from the registration or recognition of any for the trade union specified in Part A of Schedule 3 to the Trade Unions Act, the employer shall be members of the union for the purpose of paying contributions to the trade union so recognized, and B, pay any sum so deducted to the union, but a worker may contract out of the system in writing, and where he has done so, no deductions shall be made from his wages in respect of contributions mentioned in paragraph A of this section. Number 4, no deductions shall be made from the wages and salaries of persons who are eligible members of any of the trade unions specified in Part B of the Schedule 3 to trade unions, except the person concerned has accepted a writing to make voluntary contribution to a trade union. Following from the above, I will simply state that without the express consent of the claimant, the defendant cannot deduct his salary by relying on Exhibit OH6. Accordingly, claimants relief 2 and 10 are grantable and therefore succeed. Claimant also asked for a declaration that his indefinite suspension without pay is unlawful because it's not provided for in the employee handbook, Exhibit AA3. However, the defendant contended that Exhibit OH8 is the latest and applicable version of the employee handbook. Article 61 of Exhibit OH8 referred to by the defendant states as follows, and I quote, the following are the offenses that may attract such disciplinary procedure in item 58/59 above, which can be subjected to a fine or suspension from work, unquote. My understanding of Article 61 above is that the word suspension does not mean indefinite suspension, and it does not also necessarily mean suspension without pay. There are 2 types of suspension: suspension pending inquiry and suspension as a punishment. The former is not a punishment per se, for if the employee is not found guilty, suspension will be lifted and he will be enabled to receive full wages for the period, as he was never suspended. On the other hand, suspension imposed on the establishment of guilt is in the nature of punishment. It can have adverse impact on the career prospect of the employee within the organization. The point to underscore, however, is that suspension, whether pending inquiry or as a punishment, is not termination or dismissal. The contract of service remains subsisting and unbroken until it is lawfully brought to an end by either party. See the case of Akin and Uni-Ilorin, Walwork and Fielding, Bad and British Limited, Mobile Producing Company, and Udo, City Central Group of Companies, and Eze. Generally, the law is that an employer has inherent powers to discipline its employee according to contract of employment, while the conduct of the employee constitutes a misconduct or infraction. See the case of Arenzi and Fastback. Similarly, an employer has the right to suspend any of his or its staff if there exists reasonable ground to do so. In the case of Udema and Nigerian Coal Corporation, the Court of Appeal has held that the right to suspend an employee is available to an employer in order to effect proper investigation of allegations or during the process of a disciplinary action. The right to suspend an employee when necessary, either as a punishment, as in the instance case, or to enable the investigation of an infraction, is an integral part of the employee's right to discipline a staff, but other than as aforesaid. In the regulation of an employment relationship, the power to suspend an employee is not an implied term in an ordinary contract between an employer and employee. The Labor Act did not make a provision regarding suspension a mandatory requirement. This is the case of Longi and First Bank of Nigeria. Yes, in suspending an employee for the purpose of investigation or disciplinary action, the employer must comply with any existing regulation governing procedure, but such power can only be the creation of either a statutory governing body of an express term in the contract itself. Therefore, while a contract of employment is not one with statutory flavor, for suspension to be validly made, it must be so provided in the employment contract or in the handbook regulating the terms of the employment. See the case of Globe Motors Holding Nigeria Limited and Oyole, Elizabeth and Ondo JSC. So since suspension is not termination of employment, no dismissal of the employee, the implication is that the employee is still in continuous employment of the employer until it is recalled or formally terminated or dismissed, pending his recall or dismissal. A suspended employee is entitled to his wages or salary during the period of suspension, unless the terms of the contract of employment or the letter of suspension itself in specific letter of, or let the contract of employment or letter of suspension itself is specific that the suspended employer will not be paid salary during the period of suspension. In the instance case, both the employee handbook exhibit AA3 and OH8 did not state that an employee, the claimant can be suspended indefinitely and will not be paid salaries. Claimant's letter of employment exhibit AA1 did not also contain any terms with regards to suspension without pay. While suspension did not indicate that suspended employer will not be paid salary or will be on half pay, the suspended employer is entitled to his emolument during the period of the suspension. It is instructive to state that the basic and most important right of an employee is the right to his wages. And an employer is obligated to pay wages to an employee during the period of suspension, as his wages cannot be affected by indefinite suspension. See the case of Globe Motors Limited and Oyole. Given that the right to suspend an employer is not an implied term of an employment contract at common law, then it will appear that placing the claimant on indefinite suspension without pay, the manner the defendant did in exhibit AA5, in the absence of any such express provision exhibit AA3 and OH8 is unlawful. The defendant should have simply terminated the appointment of the claimant At the very time it felt dissatisfied with its response to the query, but it went to issue the claimant an indefinite suspension without pay, which is not provided for in either of the employees' handbook presented by the parties. Considering the above, therefore, reliefs 1, 3, and 4 of the claimant succeed. I need to observe that the claimant has tendered his termination letter, Exhibit A18, which is dated 13/3/2020. It appears to be a document issued by the defendant pending proceeding, which is rendered inadmissible by the prohibition of the Evidence Act. The claimant has tried to argue in his written address that he received Exhibit A18 on 16/7/2022, and so his termination will take effect from that time. I will, without any hesitation, disregard that contention because it was not pleaded. Suffice it to say that counsel's submission cannot take the place of evidence. Exhibit A18, being a document not pleaded and made pending the pendency of the proceedings, is also expunged. For the claimant's relief, 6, 7, 8, and 9, and 13, for the claimant's reliefs, 6, 7, 8, 9, and 13, in my view, there is no credible evidence in support of the said reliefs. They therefore fail and are declined. In view of all the reasons stated above and the circumstances of this case, claimant's case succeeded in part, and for the avoidance of doubt, I make the following declaration and orders. Number 1, a declaration that the indefinite suspension of the claimant by the defendant without pay is unlawful, be not provided for in the contract of employment between the parties. Number 2, a declaration that the willful reduction of the sum of 45,000 naira from the salary of the claimant for the period of September 2015 to May 2016, respectively, by the defendant without the claimant's prior and express consent is unlawful. Number 3, the defendant shall pay the claimant the sum of 405,000 naira, being the total sum illegally deducted from the claimant's salary without his consent from September 2015 to May 2016 at the rate of 45,000 naira per month. Number 4, the defendant shall also pay the claimant the sum of 79,000 naira, being the claimant's prorated salary for the remainder part of the month of August 2019. Number 5, the defendant shall further pay the claimant the sum of 753,563 naira, being the claimant's salary for the period of September to December 2019 at the rate of 190,000 naira per month. The claimant shall be paid his salary by the defendant from the 1st of January 2020 to the 20th of February 2020 when the suit was filed. The defendant is directed to pay the claimant's statutory pension contribution for the month of December 2014 and from the period between September 2015 to August 2019, and the outstanding pension contribution the defendant failed to remit for the period between January 2015 to August 2015 into the claimant's standing retirement savings account. Claimant's claims for bonus tied to the defendant's financial performance are refrigerator, Christmas entitlement for the year 2019, 2,500 naira, being the equivalent of the daily meal, and a 10% interest, prejudgment interest are hereby declined. 100,000 naira cost is awarded in favor of the claimant against the defendant. Judgment sum shall attract 10% simple interest until it is fully liquidated.
We're very grateful, my Lord, for the well-considered judgment. We're very much obliged.
Thank you, Mr. Chidozi. Yes, Dero.
We thank my Lord for the industry my Lord has shown in delivering this judgment. We shall abide and comply with the terms of the judgment. We're grateful for that.
Thank you. So this Captain Orenuga Haja.
Yes, that's 301, 2019.
Yes. Orenuga.
Yes, my lord, I'm present.
Mr. Nwagbara is online.
Yes, Chief Nwagbara is present.
There is no defendant, my lord.
Okay, there's no defendant.
It was not defendant.
Yes, the Claimant's Council.
Yes, my lord. I am Chief O.E. Nwagbara. O.E. initials. Chief O.E. Nwagbara. Nwagbara is spelled N-W-A-G-B-A-R-A.
B-B.
G for girl, G for general, and B for Bali, General Bali, my lord. For general and Bali. Chief O.E. Nwagbara, N-W-A-G-B-A-R-A, my lord.
Nwagbara.
Nwagbara, yes. Yes.
For the claimants.
I appear for the claimants, my lord.
But Mr. You're alone?
I'm alone, sir. I'm alone, my lord.
Okay, Mr. Nwagbara, I want to ask you a few questions before I proceed.
Yes, my lord.
The claim among the plaintiffs in the suit before the federal high court. That's so.
Sorry, my lord.
I said the claimants, the 8 claimants in this case.
Yes.
Are among the plaintiffs at the federal high court, before the federal high court.
Yes, my lord. They were added by the defendants.
Whether they were added or not, their names are there.
Yes, my lord, their names are there, yes.
And the federal high court gave a consent judgment, isn't it?
Yes, federal high court gave a consent judgment. And in fact, my lord, the way they were added to that suit,
yes,
the way they were added to that suit was the defendants here.
My lord,
the defendants here.
Let me ask my question.
Yes, my lord.
They are part of the suit before the federal high court.
Yes, my lord.
Where consent judgment was given.
Yes, my lord.
And at the federal high court, they claim for the same wages.
Well, my lord, that's what I tried to.
They claim for the same wages alongside the defendant.
Yeah, these same wages. The defendant were their employer. The defendant in this suit was the employer of these claimants here.
Yes, the defendant here were part of the claimant, were part of the plaintiff there.
Yes, my lord.
And consent judgment was given.
Yes, my lord.
And there are other plaintiffs in that case because
there were other plaintiffs. Yes, my
lord. Because the plaintiffs there are about 20.
Yes, there were other plaintiffs. Yes.
So that consent judgment was the same issue of wages, isn't it?
Well, yes, it was. Well, they arrested the vessel. It was not just the issue of wages. It was contract. Contract for work done.
The suit at the federal high court.
Yes.
The suit at the was for the wages of the claimants.
It wasn't. No, it wasn't. It wasn't really for the wages of the claimant.
Oh, okay. It was for what?
It was for, the defendants here are vessel managers. The defendants here are vessel managers. They did some contract for the owners of the vessel. And in their employment were the claimants in this case. So when the owners of the vessel refused to pay them, they filed an action against the owners, arrested the vessel for the contract that they performed for the owners, including the monies that they were supposed to pay their employees, which they were not able to pay because the money was not paid to them by the person they worked for, the ship owners they worked for. So when they got that judgment, they not only kept the money that was paid for the contract, but all the claimants that they represented, they kept their own money as their employers.
Okay, so the question I want to ask is,
yes,
the terms of settlement there,
yes,
and the consent judgment,
yes, include
the claimant's wages.
Yes, the consent judgment was included. It was actually negotiated.
Yes, what I want to ask is that the claimant's wages
were part of what was paid to them under the consent judgment.
Under the consent judgment, and consent judgment was given. The amount there was the amount agreed to be paid was $100,000 US dollars.
Yes, $100,000 US dollars. Yes, ma'am.
Yes. And although they claimed so much, $232 US dollars.
Yes.
But they were given.
They claimed 232,335.25.
Yes, but consent judgment was reached.
Yes.
And
yes,
$100,000 US dollars was given.
Yes, my lord.
Not only for the 7th claimant, but for the 18th claimant there.
Yes, my lord.
So since there was a consent judgment with respect to the wages of the claimant,
yes,
granted by the Federal High Court.
Yes, my lord.
Then why should you come to this honorable court to claim a different amount? The 100,000 naira given.
Exactly, my lord.
Let me land.
Yes, my lord.
The 100,000 naira, the 100,000 US dollars granted by the Federal High Court as the consent judgment.
Yes, my lord.
Was include the claimant's wages.
Yes, my lord.
And it was for 15 or it was for 20 claimants.
Yes, my lord.
Then why should the claimants, only 8 claimants, come to this honorable court claiming something that is higher and above the amount given by the Federal High Court?
Yes,
as consent judgment.
Exactly, my lord. The reason was because, my lord, after the defendants collected the money, the claimants here approached the defendants to pay them the portion of that.
Which money? Which money?
No, the claimants here approached the defendants.
No, which money? The money entered as consent judgment. Is that not so?
Yes, the money entered as consent judgment, yes.
And that is 100,000 US dollars.
Yes, yes.
And this 100,000 US dollars was meant for 18 claimants.
Yeah, my lord, I understand it very well, my lord's observation.
Yes.
When they approached them to pay them a portion of that money that was paid by the Federal High Court, paid on the order of the Federal High Court, they agreed, the defendant agreed to pay that money.
Yes.
And then the defendant procrastinated the payment, gave them different days of payment, and finally, when they were not forthcoming, the claimants here wrote to them and said that, look, we have compromised the salary that you are supposed to pay us as per the judgment. If you don't pay us on a particular date, I'm allowed all these dates, all these documents are before your lordship. If you don't pay us on a particular date, we are going to stick to our claim as outstanding in your books, which you signed and gave to us.
But Mr. Can the parties vary the judgment of the court? Judgment of the Federal High Court. This is what the judgment of the Federal High Court said, that the claimants and others,
yes, my lord,
should be paid 100,000 USD, American dollars.
Yes.
That 100,000 American dollars was not meant for only the claimants here. there are other people that are going to benefit, from that $100,000.
Yes.
That not so. So why should they now come, and begin to vary that judgment?
Yes, well, that's what I have explained. After the defendants refused to pay what was due to the claimants, as agreed between them based on that consent judgment.
Yes.
The claimants gave them all the leeway. In fact, they said they were burying their mother. They gave various excuses why they did not pay at the same time. Then finally, the claimants told them that if you do not pay my money, then I am not going to accept a compromise figure.
When did the claimant tell them that? Show me the document that the claimant tell them that when they didn't pay the consent judgment sum, that they are going to claim the whole amount. When did they in which of the documents?
I'm looking at.
Okay, look at them well.
I'm looking at.
What you do is that maybe I'm going to stand it down for you.
I'm looking at the witness statement. My lord, I'm looking at the witness statement.
Okay.
I'm shuffling the.
And I also want you to, Mr. Mwabara.
Yes, my lord.
I want you to know that the terms of settlement.
Yes, my lord.
Was filed on the. I mean the consent judgment.
Yes.
Was delivered on 22nd of January 2019. 22nd of January 2019.
I'm trying to look at it.
All the other documents, predates the consent judgment.
All the
documents, the emails exchanged between the parties. You understand? They predate the consent judgment.
The consent judgment was entered
22nd of January 2019.
22nd
of January.
Yes, it was entered on the 22nd day of January 2019. Yes.
Okay, so when did the claimants, when did they tell the defendant that if they didn't pay them the money entered as consent judgment, they are going to revert back to their former claim?
Well, I think that document was exhibited,
I'm going to give you time to check well, to go through your papers well.
My lord, I appreciate
Go through them very well. I'm going to deliver the other judgment so that when you come back, we'll continue to discuss the other.
That document was executed on the.
No, I said I'm going to give you time.
Yeah, okay, my lord. Okay, my lord. Okay, my lord.
Just 10-15 minutes to allow you to go through the.
As God pleases. As God pleases. I'm grateful, sir.
Aja, let's get to go. God is good. Aja.
Yes, my lord.
The God is good motors. NICN 2019.
2019. Between Emmanuel Eshebri Nama and God is good motors.
Yes.
The defendant counsel is online. I've been seeing the claimant counsel, Mr. Lekan Kilanko, online for some time, but I can't find him online now. Okay, he's back. He's back. So my lord can go.
It's Nuruddin, Mr. Nuruddin Balogun.
That's the defendant counsel. The claimant counsel is Olalekan Kilanko.
Okay.
Okay.
Yes, Mr. Balogun, Nuruddin. Mr. Nuruddin Balogun.
Provide respect, sir. And no Balogun for the defendant.
Okay.
My lord, the claimant counsel is online.
Okay.
Mr. Kilanko, can you please speak up? Mr. Kilanko.
Has he actually joined?
Yes, it's online. Yes.
Yes, Haja.
Yes, my lord.
Has he actually joined?
Yes. Yeah, he's online.
Yeah, but I can't hear him.
Mr. Kilanko, can you please speak up? Mr. Kilanko. Oh. Maybe I should call him mom and not.
Okay.
He has not now, and he said he unmute himself. He has not unmuted himself, and he said he has unmuted himself.
But he's still muted now.
Oh, hey, he's now unmuted. He has unmuted himself.
Hello, sir.
Yes, Mr. Kilamko. Yes, Mr. Kilamko.
Yes, my lord. Yes, my lord.
I can hear you.
My name is
Okay. It's okay. So this is my judgment. So the claimant commenced this suit by way of complaint and sorry, Mr. Kilamko.
sir.
Hear me? Can you hear me?
Yes, I can hear you very well. Yes, I can hear you very
If I recorded your submission right, in a final written address, did you say that your case is not based on negligence but on under the Employees Compensation Act? Mr. Clark, can you hear me?
Yes, sir. I can hear you now, sir.
Yes. I don't know whether I got you right in your oral adumbration.
Yes, sir.
You said your case was not based on negligence, but on the Employees Compensation Act. Is that right?
Very well, sir. Very well, sir.
Okay. So this is my judgment. The claimant commenced this suit by way of complaint and other accompanying processes filed on the 9th of May 2019 and asked for the following reliefs as contained in the amended statement of fact against the defendant. Number one, an order of court ordering the defendant to take the claimant abroad for treatment of his sight. Number two, compensation of 25 million naira for the loss of sight by the claimant while on duty for the defendant. Number three, general damage of 1 million naira. Number four, cost of 100,000 naira for being the cause of this action. The defendant, upon being served with the claimant initiating processes, filed its memorandum of appearance on the 4th of July 2019, but filed a statement of defense on the 3rd of August 2019 via leave of court granted on the 8th of October 2019. The defendant also filed a notice of penal objection, which was struck out at the instance of the defendant. Case of the claimant. From the amended statement of fact filed by the claimant, he was engaged as a driver by the defendant company and worked for 7 years. That while working with the defendant, there was no insurance policy taken by the defendant regarding his life and job risk. That on 24th January 2019, while the claimant was on official assignment to discharge passengers on board the defendant vehicle, registration number 439VN from Lagos to Port Harcourt, he was attacked by armed robbers who shot at him, as a result of which he lost his sight completely. That the claimant was taken to Port Harcourt Teaching Hospital by the passengers on board, the assistance of some policemen on patrol. However, his sight could not be restored both at the Teaching Hospital and Eye Foundation Lagos, where he was transferred to at the request of the defendant. It was stated by the claimant that the defendant only paid him 40,000 naira from January 2019 to March 2019. Case of the defendant. It is the defense of the defendant that the claimant was engaged as one of his drivers to drive his buses across the country, that they were engaged under a contract for service as professionals to render service to the defendant as independent contractors, but not as employees of the defendant. Hence, they were not issued any letter of employment. It was stated by the defendant that the reported armed robbery shooting that led to the loss of the claimant's sight was not an act of the defendant or any of his agents, but that of the third party. It was also stated by the defendant that the loss of the claimant's site was not directly caused by any accident involving any equipment of the defendant. According to the defendant, it is not obliged to provide the claimant with any life insurance cover. The defendant took the claimant to I Foundation Hospital after he was discharged from Port Harcourt Teaching Hospital to enable the claimant benefit from the health insurance available in the defendant company. It was stated by the defendant that it's not obliged to pay the claimant any compensation beyond the fees due to him as an independent contractor. Trial in this case commenced on the 22nd of June 2021, where the claimant testified at CW1 by addressing his amended assessment on oath, dated 9th March 2020, and tendered the following documents as exhibit. Exhibit EE1, EE2, A to D, EE3, A to B, EE4, EE5, EE6, and EE7. CW1 was cross-examined by the learned counsel for the defendant, and as there was no re-examination, the CW1 was discharged and the case of the claimant was closed. The defendant in its defense called one Mr. Paul Ostrogay as DW1. He adopted his statement on oath dated on the 3rd August 2019 and tendered health insurance policy and table of fees for the claimant as exhibit GGM1 and 2 respectively. DW1 was cross-examined, and as there was no re-examination, he was discharged and the matter was adjourned for adoption of final written addresses. Defendant's final written addresses was filed on 21st of October 2012, wherein counsel for the defendant submitted 2 issues for determination to it. While the injury sustained by the claimant is covered under the Employees Compensation Act, where the claimant has proved the compensation and damages claim judging from the circumstances of the case. Another counsel on issue 1 submitted that it is clearly submitted during the trial that the loss of the claimant's site was as a result of the shooting carried out by armed robbers who attacked the defendant's boss when the claimant was driving same to discharge passengers. Counsel also submitted that the Employees Compensation Act provides for compensation for any employee who sustained injury during the course of his employment with his employer. However, the position of the law as laid down in the case of Chidi, Carlo, and International Properties Limited is that for a claimant to qualify for compensation under the Employees Compensation Act, the employment must be the cause of the injury, and the injury must have occurred in relation to that employment or incidental to the employment. Counsel also referred to the case of Chidi Kalu Mba International Properties Limited on what amounts to during the course of employment. Counsel mentioned that although the injury was incidental to the employment was not the cause of the injury. The shooting that resulted in the loss of the claimant's eyes was carried out by third parties outside the contemplation of the claimant's employment with the defendant. The injury sustained by the claimant was not in the course of the claimant's employment with the defendant, notwithstanding the fact that the claimant was directly engaged by the defendant and was driving one of the defendant's buses attached to him carrying passengers from Lagos to Port Harcourt when the incident happened. The counsel argued that the claimant is not qualified for compensation under the Employees Compensation Act. On issue 2, counsel posited that, assuming without conceding that the employment was the cause of the injury and that the claimant sustained the injury in the course of his employment with the defendant and entitled to compensation under the Employees Compensation Act, what should be left is whether or not the damages claimed by the claimant had been proved to entitle him to same. The counsel argued that by Section 12(3) of the Employees Compensation Act, any employee who sustained injury during the course of employment is allowed to choose either to claim for compensation from the fund created under the law for that purpose by applying to the board of NSITF or file an action against the employer or any other party that caused the accident that resulted in the injury. Counsel further argued that the employee shall reimburse the board where it succeeds in the action and obtains judgment in excess of the compensation already collected from the fund. But when an employee chooses to file an action instead of claiming compensation from the fund, the action shall be a bar to claim compensation from the fund. That in the instance case, the claimant has chosen to file an action against the defendant in an action which precludes him from claiming compensation from the fund, seeking his reliefs. Counsel admitted that based on the formula provided by the Employees Compensation Act and the amendment of the claim in paragraph 8 of his amended statement of fact, that he was 55 years of age when he sustained the injury, the claimant will have been entitled, if he had elected to claim compensation from the fund, to only 827,000 naira using his average monthly fee of 38,303 as shown in Exhibit DM2. Another council submitted that to award damages such as the ones sought by the claimant, in this case, the claimant has the duty to establish that the injury sustained by him resulted from the negligent act of the defendant or resulted from the failure of the defendant to discharge the duty of care he had towards the claimant at the time of the injury. Such in the case of Nicn and SPDCN. Counsel made the point that from the fact and evidence adduced in this case, there's nothing before the court to show that the claimant did not follow the company's instructions and processes put in place to ensure a safe journey at all times. That the attack by the armed robbers whose shooting resulted in the loss of the claimant's side was a force majeure situation totally out of the control of both the claimant and the defendant, and no causal relationship between the duty of care owed by the defendant to the claimant and the injury that resulted from the shooting by the robbers. The defendant, having not negligently caused the injury sustained by the claimant, is not liable for negligence to the claimant, and that the claimant is not entitled to any award of damages from the defendant. Claimant's final written address. Claimant's final written address, which was filed on 22nd of January 2022, was deemed as properly filed and served via leave of court. The final written address as submitted by the Land Council for the claimant contains 3 issues for determination 2. Number 1, whether the claimant is an employee of the defendant. Number 2, whether the injury sustained by the claimant arises out of and in the course of employment. Number 3, whether the claimant can exercise his right under common law as against the provisions of the Employees Compensation Act. Counsel submitted on issue 1 that by virtue of Exhibit EE1, which is the claimant statement of account that shows payment of salary into the claimant's account by the defendant, and Exhibit EE7, the identity card issued by the defendant to the claimant is an employee of the defendant and is therefore entitled to the relief sought. Counsel submitted on issue 2 that it is the claimant's undisputed evidence that he was shot by armed robbers, which led to his loss of sight while on duty on his way to Port Harcourt to discharge passengers on board. By provision of Section 7 of the Employees Compensation Act, any employee, whether or not in workplace, who suffers any disabling injury, other than out of or in the course of employment, shall be entitled to payment of compensation. The compensation shall be paid to such employee provided the employer has prior notification of such place. Citing Section 7 subsection 2 of the Employees Compensation Act and the case of UAC and Orekin. Counsel also submitted that the injury sustained by the claimant, though occasioned by the third party, arose out of in the course of employment, that the claimant is entitled to compensation. The counsel submitted on issue 3 that the claimant had the right to seek redress under the common law, and that Section 12 of the Employees Compensation Act makes provision for the right of the employee to seek redress where injury or disability arises out of and in the course of the employment, as in the instance case. That the Act in its provision did not abolish the common law principle of negligence. That the defendant never placed before the court its total and minimum monthly contribution to employees' compensation fund, hence leaves the claimant with the only option of approaching the court for compensation. Counsel submitted that under the Common Law Employees Compensation Act, the claimant is automatically entitled to compensation without further proof, and the quantum will depend on the degree of injury, the number of dependents, and condition of life, citing Section 70 and 71 of the Employees Compensation Act. In his oral adumberation, claimant's counsel argued that the claimant's case is not based on negligence, but under the Employees Compensation Act. Defendant's reply on points of law to the claimant's final address. The defendant filed its reply on points of law to the defendant's final written address on the 1st of February 2022. Counsel argued that the quantum of compensation under the Employees Compensation Act is dependent on the degree of injury, number of dependents, and their condition in life. The counsel submitted that the claimant relied on Section 70 and 71 of the Employee Compensation Act, which are not applicable to the quantum and condition for compensation payable to an injured employee, either under the Act or the common law. The compensation payable to an injured employee under the Act is provided in Section 17 as analyzed in paragraphs 5.15 and 5.23 of the refinery written address. Council rely on the case of Suleiman and Hongxin Steel Company Limited. Council further submitted that, contrary to the contention of the claimant, the quantum of compensation under the common law is dependent on the claimant's claims before the court, and that the claimant's ability to establish those claims according to law. It doesn't depend on the degree of injury to the claimant, number of dependents, and all their condition in life. I've carefully considered the pleadings of the parties and the evidence adduced. I've also studied the submission of the respective counsel for the parties in the written addresses. 2 issues for termination were submitted by the defendant, while the claimant submitted 3 issues for termination. Let me quickly start off with the claimant's first issue for termination, which appears preliminary. The issue is whether the claimant is an employee of the defendant. The defendant has stated that the claimant was engaged as one of his drivers under a contract for service to render service to the defendant as independent contractor, but not as an employee of the defendant. Hence, he was not issued any letter of employment. However, the claimant has argued that he was an employee of the defendant, and in trying to prove that, he has presented his bank statement of account and identity card, exhibit EE1 and EE7. Now, a contract of employment means any agreement, whether oral or written, express or implied, whereby one party agrees to employ another as a worker, and that other person agrees to serve the employer as a worker. A worker is defined by the Labor Act as any person who has entered into or works under a contract with an employer, whether the contract is for manual or clerical work, or is expressed or implied, oral or written, and whether it is a contract of service or a contract personally to execute any work or labor. But where a contract allows the contractor to work for people other than the employer, that person is referred to as independent contractor or self-employed. See Section 91 of the Labor Act. The definition given by the Labor Act applies to workers strictly to the exclusion of the management staff. See the case of Shena Security Company and Afro-Park Nigeria Limited. There are factors which usually guide the court of law to arrive at the right conclusion to the kind of contract the parties have entered into. For instance, if payments are made by way of wages or salaries, it is indicative that contract is one of service. If it is a contract for service, the independent contractor gets his payment by way of fees. In the same vein, where payment is by way of commission only or on completion of the job, that shows that the contract is for service. Similarly, where the employer supplies the tools and other capital equipment, there is a strong likelihood that the contract is that of employment or of service. But where the person engaged has to invest and provide capital for the work to progress, that indicates that it is a contract for service. See the case of Shena Security Company Limited and Afro-Park, Supra, and Milway Southern Limited and Wilshire. It was stated by DW1 under cross-examination that the claimant was driving a bus for the defendant. DW1 also stated that the job of the claimant is part of the business of the defendant, and that the claimant can be sanctioned by the defendant if he misconducts himself while working with the defendant. Exhibit EE1 shows that the defendant had been paying the claimant's salaries. Meanwhile, Exhibit EE7, which is the claimant's identity card, indicates that the claimant is a staff of the defendant. And going by all this, and coupled with the fact admitted by the DW1 under cross-examination that the claimant worked for the defendant, I'm of the opinion that the relationship between the claimant and the defendant is that of contract of service. Hence, the claimant is an employee of the defendant and not an independent contractor. Contrary to the contention of the defendant that there is no letter of employment issued to the claimant, it is my view that absence of a letter of employment does not actually mean that there is no employment relationship between an employment, because an employment contract, like a simple contract, may be oral or by conduct. See the case of Adodoyin and Igbo Development Company. Turning to the main claim of the claimant, claimant has submitted that he has the right to seek redress under the common law under Section 12 of the Employees Compensation Act makes provision for the right of the employee to seek redress where injury or disability arises out of and in the course of employment. It was also argued by the claimant that under the Common Law or Employees Compensation Act, the claimant is automatically entitled to compensation without further proof, and the quantum will depend on the degree of injury, the number of dependents, and the condition of life. However, claimant's counsel in his oral submission argued that the claimant's case is not based on negligence, but under the Employees Compensation Act. Though the claimant does not intend to base his case under the common law principle of negligence, even at that, for a claimant to succeed in a case rooted in negligence, he must prove by quote and credible evidence that the defendant owes a duty of care to him, that the duty of care was breached, and that he suffered damage arising from such breach. See the case of Cabo Air Limited and Muhammad, SPDC Limited and Econtia. Now, negligence is the omission. Now, negligence is the omission to do something which a reasonable man guided upon consideration, which ordinarily regulates the conduct of the human affairs would do, or doing something which a prudent and reasonable man would not do. It means lack of proper care and attention, careless behavior or conduct, a sort of mind which is opposed to intention, and the breach of a duty of care imposed by common law and a statute resulting in damage to the complainant. It is the failure to exercise the standard of care that a reasonably prudent person would have exercised in a similar situation. It is also any conduct that falls below the legal standard established to protect others against a reasonable risk of harm. See the case of Cabo Air. In any event, the Employees Compensation Act 2010 has made provisions for making claim by an employee who sustained injury in the course of his work. A person making claim for injury under the Employees Compensation Act cannot directly come to this honorable court. He can only come to the court after making a direct claim to the appropriate body, that is the Nigerian Social Insurance Trust Fund Management Board. It is obvious that an employee can file an action for negligence under the common law, but he must elect that only if he is dispensing with the ECA process. See section 12(1) and 3 of the ECA. While the claimant elects to make claim under the Employees Compensation Act, it is the NSTF board, management board, that determines what is payable for permanent total disability or permanent partial disability as provided under sections 21 and 22 of the Act. It is when the claimant is not satisfied with the outcome of his claim under the ECA that he can approach the NICN after exhausting all the processes of the ECA. See sections 51, sub 1, 2, 3, and 4 of the ECA. See also the decision of this honorable court in the case of Mr. Agbo, Jeffrey, and Dangote AgroSac Limited, or reported suit number NICN/LA/315/2013, judgment of which was delivered on the 7th December 2017. Also, the case of Ola Suleiman and Honging Steel Company Limited, or reported, judgment of which was delivered on the 6th of February 2015, and the case of Amin Hassan and Airtel, or reported, the ruling of who was delivered on the 11th of February 2015. Although Land Counsel for the claimant has submitted in his oral submission that the claimant's case is not based on negligence, but under the Employees Compensation Act, but it does not appear that, it does not appear that the claimant has exhausted the process of the claim for compensation under the said Act. A claim for compensation under the Act is in lieu of any right of action which the injured employee may have against the employer. The provisions of section 4, 5, and 6 have clearly provided the procedure for making a claim under the ECA. If the claimant has elected to pursue his claim under the ECA, then he will be stopped to, at the same time, pursue claim under the common law on negligence. For a claimant to have a valid claim, he must elect to either claim compensation under the ECA or claim on negligence under the common law, and not combine the two claims in an action before the court. Since the claimant decided to pursue his claim under the ECA and not under the common law principle of negligence, then the provisions of section 12(1) and 3 of the ECA, which provide as follows, are instructive. And I quote, the provisions of this act are in lieu of any right of action, statutory or otherwise, founded on any breach of duty of care or any other cause of action, whether the duty or cause of action is imposed by or arises by reason of law or contract, express or implied, which an employee, dependent, or member of the family of the employee is or may be entitled against the employer of the employee, or against any employer within the scope of this act, or against any employee irrespective of any death, injury, or disability arising out of and in the course of the employment, and where no action in respect of it lies. Where the cause of death, injury, or disability of an employee is such that an action lies against some person other than an employee or employer, the injured employee or deceased employee's dependent may claim compensation or may bring an action. And if the employee or dependent elects to claim compensation, the employee or dependent shall do so within 6 months of the occurrence of the injury or death or any longer period, as the board may, from time to time, determine. An election by the employee or dependent to bring an action in court shall be a bar to claim compensation from the fund in respect of such injury, liability, disability, or death on court. A careful perusal of the above provision of the ECA will reveal that a claimant may elect to claim under the ECA or bring an action under the common law rule of negligence, and not to pursue two claims at the same time. Since the claimant is claiming under the ECA, it is the NSITF Management Board that determines what is payable as compensation. To my mind, the claim of the claimant is inappropriately before this honorable court. He will need to exhaust the claim processes of the ECA and the prerequisite before he can come to this honorable court for a claim for compensation. Given the circumstances of this case, I hold that the claim of the claimant under the ECA is premature and thus liable to be struck out. Consequently, the claimant's case is struck out for non-fulfillment of the condition precedent to the institution of this action. This is without prejudice to any available means to claim for compensation through the NSITF under the Employees Compensation Act. This by my judgment.
We are very grateful for the well-considered judgment. It's rather unfortunate that it has come to this. Yes. We felt for the loss of the sight of the claimant, and we have done everything humanly possible to see how that could be redressed without us getting to this level. But anyway, yes, since I still have the room to go back to NSITF.
Yes.
Yes. So
because the issue is that before this court, if you are coming under the principle of negligence, you have to prove. Common law principle. You have to prove negligence.
Exactly, my lord. Exactly.
So, and I don't think there is the defendant was negligent in the loss of sight of the, because it was done by a third party.
My lord, that has been my position. And unfortunately, my learned colleague on the other side did not see it that way. So that's why it's even very painful, more painful, because this we are trying to even settle amicably, and the company
yes.
That's unfortunate. So, my lord, we are most grateful for the decision.
But Mr. Nuruddin, Mr. Balogun.
Yes, my lord.
Why wouldn't you go and sort out through the NSITF, please?
Well, but my lord, like I said, since I still has the right to, my lord is just striking out the man so that I could still go back.
Yes,
so, but we will be ready. We will make ourselves available and do whatever is possible for him.
Please, to Mr. Baise, it's a painful thing, Mr. Balogun.
It is, my lord. It is. Personally, me, I'm feeling the pain. And like I told my learned colleague that I'm not going to be happy if this thing gets, and unfortunately it has got into this. My lord, we will do whatever in our own power to assist I will talk to the management.
Yes, do, please.
Whatever we can do to support the claimant. My lord, we are most grateful for the time.
You should look at the whole thing, the circumstances of the case, the country.
Yes.
Even if you are employed, how are we coping? Chocolate of somebody that's not employed and that has lost his sight.
Yes, yes, madam.
Yeah, please.
We'll do what is humanly possible to support and assist the claimant. I'll talk to the
please, Mr. Nren.
We'll do that, man. We are most grateful, sir.
Okay.
Good. Thank you,
Thank you so much.
Thank you.
Okay.
May I please, my lord, my lord, this is Chief Mwabara, sir.
Okay.
Just remind my lord that we had a stand down.
Yes. Just hold on.
As God pleases.
Yeah, just a minute, yes. Yeah, so, Mr. Mwabara, what did you...
Yes, my lord. Yes, my lord raised the issue that the emails we exchanged predated the court order.
Yes.
Of January 22nd.
All the emails.
Yes, my lord. Yes, my lord.
All the emails.
Yes, my lord.
Yes.
My lord, in fact, we didn't want to use the word fraud because of future business interests of the defendants. You see, my lord, on the 22nd of October, on the 26th of October, that was the day that the agreement as to what was to be paid was reached. And that money was actually paid on that day. They executed that agreement and the money was paid. And the plaintiffs pursued...
Okay. Paid by who?
I mean, the owners of the vessel paid the employer of the plaintiffs, the claimants here, on the 22nd of October, 2018.
2018.
Yeah, 2018. That was the day. That was the day.
Hold on. Yes, Mr. Mwabara. They paid as per the terms of settlement.
Yes, my lord.
That is the $100,000 US dollars.
Yes, my lord. That was the day that money, was paid.
Okay, so 100,000 USD was paid.
Yes, my lord.
By the defendant, by the owners.
By the owners, yes, my lord.
To the defendant in this case.
Yes, my lord. Now, why we are claiming more than that?
That payment, that settlement.
Yes, my lord.
That settlement was the document that formed the basis of the consent judgment.
Yes, my lord.
And so it means that a subsisting judgment.
Yes, my lord.
Yes.
Yes, my lord. Why we are claiming more than what we are supposed to be entitled to based on that judgment?
Yes.
Is because before we went to court, and in fact before we started exchanging those emails, and as my lord would see there, the defendants who conducted this case on behalf of the claimants in your court, having compromised the claim, they made a proposal. They made a proposal to the claimants within that period of agreement.
Yes, I can hear you. Yes, Mr. Mwabara.
And the plaintiffs agreed, the claimants agreed. Okay, pay us.
Agreed to what?
Having collected $100,000, the defendants in this case proposed to the claimants before your lordship that they were going to pay them only 30% of what they are entitled based on their employment with them, which the claimants agreed. They agreed, and they say pay us. So having agreed that they should pay, they pay them. The day they agreed they were going to pay them, they didn't pay. They started procrastinating. It clearly out of fraudulent intention not to pay them. In the proposal they sent eventually in December, they have collected this money since October. The proposal, they tabulated the entitlement they are proposing to them based on 30%. The plaintiffs accepted it and said, we are accepting that you pay us 30% if you pay us now that you have collected the money. If you don't pay us now, we are going to claim from you what we were originally entitled as your employee. So that's the basis.
Okay.
And they didn't pay.
Mr. Mwapara.
Yes, my lord.
There is already subsisting Federal High Court judgment.
Yes, my lord.
Yes. In which order the honors to pay the claimants in this case and others, the sum of 100,000 US in US dollars.
Yes, which was like 50%. Which was like 50% of the claim they placed before the court.
Yes, and that money was meant not only for the claimants, it was meant for other plaintiffs also.
Yeah, the total amount. Yes.
Yes. So that judgment still subsists, isn't it?
Yes, it does.
So coming now to court to claim for, same wages, you understand? If I now grant your claims,
yes, my lord,
the sum of 100,000 or 105 USD. Now,
yes, my lord.
Can't the claimants,
yes, my lord,
say that they have two judgments? The one given by the Federal High Court, which is still subsisting, and the one I'm going to give today, on the same subject matter.
Yes, my lord.
How can the claimants have two judgments in the same subject matter? The judgment of the Federal High Court is still subsisting.
Yes, my lord. It's still there. It's not the same subject matter. It's not the same subject matter.
It's the same issue of wages.
Yeah, it's not the same subject matter, my lord. The subject matter before your lordship is for wages not paid. The subject matter before the Federal High Court is for contract performed to a ship owner. It is for contract performed for the ship owner. This one is for wages outstanding in the hands of an employer of labor. They are not the same thing. They are two different things.
Okay. Let me read to you what the parties have agreed on in the terms of settlement.
Yes, my lord. I have
it. Okay, yes. The reliefs of the plaintiffs, before the Federal High Court are, number one, the sum of USD 232,000.
Yes, my lord.
3 million naira, respectively, being crew wages. Crew wages.
Yes, my
due
lord.
and owed the first and 18th plaintiffs.
Yes, my lord.
As crew, and all seamen that faithfully and diligently perform their duties. And technical safety management services rendered for the operation and maintenance of the vessel, MV Soso Ocean King. The collection that the first to 18th plaintiffs are maritime lien holders, and an order directing the third to fourth defendant jointly and severally to pay the plaintiffs the claim and or judgment sum and the interest. Then the agreement, it's hereby agreed by the parties to this suit as follows.
Yes, my lord.
Although the first to 20th plaintiffs commence this suit against the defendants, the 8th, 10th, and 15th, the 15 plaintiffs claim against the first, third, and fourth defendant have been completely settled when the third, fourth, and defendant paid the 8th, 10th, and 15th defendant the respective crew wages, as evidenced by the bank statement of account, bank statement of the fourth defendant receivership. You see, it says, okay, then with respect to the claims of the 1st to 7th, 9th, 11th, 14th, 16th to 28th, the plaintiffs have against the first, third, and fourth defendant in this suit. The third defendant shall pay the first to 7th, 9th, 11th, 14th, 28th, the cumulative sum of 100,000 USD upon the execution of the terms of this settlement by parties as full and final settlement of all the issues.
Yes, my lord.
Claims and reliefs, including costs, the plaintiffs have against the first, third, and fourth defendant in this suit. So it means, okay, then the above terms of settlement shall be the full and final settlement of this suit in relation to the plaintiffs and the first, third, and fourth defendant, and shall be made the final judgment of this honorable court. So it means the judgment given by the Federal High Court includes the wages of the claimant.
Yes, my lord.
So, and 100,000 naira was given by the Federal High Court.
Yes, ma'am.
Whatever it is, whether it includes the wages and other services performed, but it's still in respect of the wages of the claimant.
I agree, sir. I agree.
So had the claimants collected that 100,000 naira from the defendants in this case and the defendant in that case, are they still going to come back to this honorable court to file this case?
The defendants collected.
No, have they collected that 100,000 USD from the defendants? I mean the claimants. Have they been paid out of that 100?
They've not been paid a dime. A dime.
My question is that have they been paid? Supposing they were paid.
They have not been paid anything out of the 100.
No, what I'm asking is that supposing they were paid.
Yes.
Based on the question judgment.
We won't come to court.
Are they still going? No, supposing they were paid.
Yes.
Are they still going to come to this court to
no, we won't.
This thing? So it means that judgment still subsists. It's still there.
Yes, my lord, but you know, my lord, the claimants here are not the employees of the owners of the vessel.
They
are employees of the managers of that vessel.
Yes, but
that is why we executed the contract.
But the suit was respect of the same issue of wages. Their wages.
Yes.
It's the same issue of wages.
Yes.
So what I'm asking is that have they been paid out of that 100 USD? Are they still going to come to this court to file this?
They won't come to court.
No, they won't. So it means that judgment of Federal High Court still subsists. It's still there.
Yes, my lord. You would have bound them, yes.
So since it still subsists, why should you come to this court to file this again, in respect of the same issue of wages?
Yes, my lord. The reason we came to this court is that the money that was meant for the payment of wages to the claimants before your lordship were collected by the employer of these complainants before your lordship.
Yes,
and the money was collected by them. Yes, and there's no other way they can collect that money from them other than going to a court.
And that money, the money that was agreed on,
yes,
as consent judgment was 100,000 USD.
Yes,
isn't it?
Yes.
And that 100,000 USD was not only meant for the claimant, for the 8 claimants.
Yes.
It was meant for 18 claimants.
Yes, my lord. Yes.
So all the 18 claimants are going to share that 100,000 USD.
Yes, my lord.
So and you now come to this honorable court claiming for 8 claimants.
Yes, my lord.
You know, a sum that is higher than the one agreed in the consent judgment.
Yes. The reason is because the claimants, having failed to receive what is due to them, even as
Yes.
proposed by the defendants to give to them, wrote
Yes.
back to the defendants and said, if you don't give me what you collected on my behalf,
Yes.
as negotiated, I
Yes.
am going to claim the whole money that is due to me originally from you. And that's why we are here. Yes.
Okay. Okay, my question is that, can the claimant vary, that consent judgment? Can they vary that consent judgment? Because even what the representative of the defendant said in one of the emails that he sent, that we're only going to give you what we receive.
Yes.
He said this.
And they never gave them anything.
And then, what I'm saying is that
my lord, we have made our presentation. It is for your lordship to take it. In fact, if they had come up with this defense, my lord, if they had come up with this defense that what we owe you is 30% of what we collected, we would have been content with it. And of course, it will be the basis for the judgment of your lordship's decision. But since they did not defend it, it means they have considered what we have claimed. That's the truth about it. Since they did not defend it, they were duly served and they decided to ignore it. It was duly communicated to them that if they don't pay in time, if they don't pay as agreed, that we are going to claim a whole sum. And they kept quiet. It is the basis for the claim. If they had come up with this defense, it would have been a basis for your lordship decision.
Okay, so let me just deliver I just read this issue to whether I'm going to hear any thing, convincing any convincing argument that would make me change my mind. But judgment is already here. Let me just read the judgment.
Yes, my lord. I was going to say that since the judgment is being delivered over 90 days, after 90 days, that I be allowed to readopt for whatever it is.
Okay.
And okay, to have been adopted from today.
Okay.
Yes, that's a humble application, sir.
Okay.
My lord. Hello, my lord. My lord, can I go offline?
Okay, sorry, Chief. Hello.
Yes,
Chief.
my lord. Yes, my lord.
Sorry, I didn't know that I was muted. I was calling, and but I realized that I was muted.
Ah, I didn't know that. I didn't know that.
Yes. So the issues I raised, okay, the matters for this one.
I hope my lord recorded that I revalidated. I re-argued our.
Okay.
We had to re-adopt to come within the 90 days constitutional limitation for judgment delivery.
I'm just trying to record that I raised some issues, with regards to the to the facts and argument in the case, and you responded and re-adopted your
as copies.
Your former your earlier addresses.
Yes, my lord.
Okay. So, Mr. Obara, this is my judgment.
Ask God, please.
Mm-hmm.
I'm with you, my lord.
Okay,
I'm here, my lord.
Thank you.
Thank you, my lord.
So, the claimant commenced this suit by a complaint and other accompanying processes filed on 27th of June 2019 and asked for the following reliefs as contained in a statement of fact against the defendant. The first to seventh claimant claimed the sum of money owed to them as wages by the first defendant when they worked on board a ship named Alisa Ocean King as seafarers, which said wages the defendant have collected on behalf of the first to the seventh claimant and have refused to pay them over to the first to the seventh claimant. Number two, the eighth claimant claimed the sum of money owed him as wages by the first defendant when he worked on board a ship named Alisa Ocean King as seafarers, which said wages the defendant denied him from collecting when the defendant committed a writing in the terms of settlement in a suit in which the eighth claimant was a party that the eighth claimant had been paid his outstanding wages, which is not the true position. Number three, interest on the said amounts of claim at the rate of 21% per annum from 22nd 10/2018 to judgment, and thereafter at the rate of 10% per annum until finally liquidated. Claim amount, total sum of United States of America dollar, 100,000, 102,000, and naira amount of 1 million naira, and as particularly stated in the demand letters, both dated 17 June 2019, addressed by the claimant solicitors to the first and second defendant. The record of the court on the 6th of November 2019 shows that the defendants were served with enriching processes on the 12th of July 2019. However, they did not file any defense process. Case of the claimant. In the claimant's case, that the first defendant employed them as seafarers in Lagos in November 2013 and deployed them to work as seafarers on board a ship named Alisa Ocean King on a specified amount per day, respectively. The defendant refused to pay them their wages despite enjoying their services. The first defendant claimed that the owners of Alisa Ocean King were owing the first defendant for contract of service performed. It was avowed by the claimant that the first and second defendant had been sister companies. Sometime in 2017, in conjunction with the claimant and others, sued the vessel MV Alisa Ocean King, Alisa Drilling and Marine Services, Diamond Bank PLC, and Olabisi Akodo, appointed receiver and manager of MV Alisa Ocean King, principally for the wages owed the claimant among other workers who worked on board the vessel at the Federal High Court. The consent judgment in the matter was entered on 22nd January 2019 as per the terms of settlement filed on 26th October 2018. According to the claimants, the defendant collected the settlement sum by using the name of the second defendant, but have refused to pay over the sums collected on behalf of the first to the seventh claimant. Claimant stated with respect to the eighth claimant that the defendant owed out his consent to exchange him by committing a writing in the terms of settlement that the eighth claimant had been paid his wages, when in fact he has not collected the same. Trial commenced on the 6th of October 2021, where one Jerry Omelo, the manager of the lawful attorney of the claimant, testified as CW1. He adopted his assessment on oath dated in 7 June 2019 and tendered exhibit MCD1 to MCD21. As the defendant were not in court nor represented, CW was temporarily discharged and the matter was adjourned to 25th January 2022 for cross-examination. On the said day set for cross-examination of CW1, the defendant was also not in court nor represented, and upon the application of the learned counsel for the claimant, CW1 was discharged and the defendant were foreclosed. The matter was then adjourned for adoption of final written addresses. Claim final written addresses, which is dated and filed on the 9th of February 2022, contains a sole issue for termination to it. where the claimants have proved their case of non-payment of wages by the defendant on preponderance of evidence placed before this honorable court to be entitled to judgment in their favor. Panel counsel for the claimants submitted that the claimants have, by virtue of sections 132 and 134 of the Evidence Act, proved their case through their witness before this honorable court, that they have established before the court that the contractual relationship they had with the first defendant as employees and employer respectively, referring to exhibit MCD 2 to MCD 9, which contain the terms of contract, the number of days each of them worked for the first defendant, the wages each was entitled for the days of work, and the refusal of the first defendant to pay their respective wages. Counsel also submitted that the claimants have established how similar sum in exhibit MCD 10 was collected by the defendant and the refusal to pay over the sum collected on behalf of the claimant. It was also established how the eighth claimant was exchanged, citing also Order 48, Rule 1 of the rules of this honorable court. Panel counsel first submitted that the defendants are bound by the contract they enter with the claimants, and the claimants are entitled to damages for failure of the defendant to pay the claimants their wages as an undue, citing Section 15 of the Labor Act and the case of Waek and Shinobi. It is submission of a counsel that when the court relays the employment contract of the respective claimants with their complaint and the evidence placed before the court will come to the irresistible agreement with the claimants on their claim to wages. The court will also agree with the claimants that the defendant are in breach of the contract of employment and are indebted to the claimants for monies duly collected on behalf of the first to the seventh claimant, having refused to pay same over to the said claimant, and that the defendant should change the eighth claimant. Counsel finally submitted that the claimants have proved their case against the defendant and are entitled to judgment in their favor. So, court's decision. As it was noted and observed earlier, the claimant initiated this case through their lawful attorney, and from a careful perusal of the averment filed by the claimants and the documentary and oral evidence presented, claimants were employees of the first defendant as seafarers and deployed to work on board a ship named Adesa Ocean King. But the first defendant refused to pay them their wages, claiming that the owners of the Adesa Ocean King were owing the first defendant for contract of services performed. Claimants, in conjunction with the defendant and some others, sometime in 2017, instituted an action at the Federal High Court against the vessel MV Adesa Ocean King, Adesa Drilling and Marine Services, Diamond Bank PLC, and Olabisi Akodu, appointed receiver, stroke manager of MV Adesa Ocean King, claiming for the sum of $222,000 and 3,991 naira as their wages, but for reaching amicable settlement. Consent judgment in the matter was entered on the 22nd of January 2019 as per the terms of settlement filed on the 6th of October 2018, where, according to the claimant, the first and second defendant collected the judgment sum by using the name of the second defendant, but have refused to pay over the sums collected on behalf of the first to seventh claimant. It was stated in the terms of settlement, Exhibit MCD 11, that the eighth claimant and others have been paid and the claims completely settled. It was further stated in the said exhibit MCD 11 that the sum of $100,000 shall be paid to the first and 20th plaintiff, wherein save the 8th, 10th, and 15th plaintiffs as full and final settlement of all the claims against the defendant in that case. In trying to prove their case, the claimants are presenting on one exhibit. Exhibit MCD 1 is the power of attorney, while exhibit MCD 2 to 9 are job offer letter of the claimants. However, I observed that exhibit MCD 3, the offer letter of the third claimant, is not signed. In any event, it was one of the judgment creditors as shown in the costing judgment. I also observed that the name of the seventh claimant, Shakiru Sani, is not reflected on the process filed at the Federal High Court. However, it was the name of one Sani Rizuku Abimbola that was stated therein. Exhibit MCD 20 and 21 dated 17 January 2019 are demand letters sent to the defendant respectively, and the defendant responded respectively, by the claimant solicitors. However, the consent judgment exhibit MCD 10 was issued on the 22nd of January 2019. It's clear that the demand letters precede the consent judgment of the Federal High Court, and the sum of the money and the sum of money claimed in the demand letters, which is consistent with the relief's claim, is $102 and 1 million naira for the claimants respectively in the instance case. However, the sum entered as consent judgment was $100,000 for 15 plaintiffs at the Federal High Court. It can be observed that there appears to be a discrepancy between the amount claimed by the claimant in the instant case and the amount entered in the consent judgment at the Federal High Court. The question which I wish to ask is whether the claimants having participated in the suit at the Federal High Court as plaintiffs can claim an amount before this honorable court in the same subject matter higher than the one given by the Federal High Court as consent judgment. I need to state here that parties to a dispute in court are entitled to determine the dispute in agreed terms. Such agreed terms may on their own may on their demand be entered by the trial court as its consent judgment. It's elementary that once entered, the consent judgment serves as a final determination of the dispute between the parties, and it is as effective in law respect of all the matters which are there set as any other judgment or order arrived at after the matters are fully fought out to the end. In the case of Vulcan Gases Limited and 4 industries, Gas Power Age, Race Auto Supply Company Limited, and Idigbe, Star Paper Mill Limited, and Adetunji. In Adetunji and Osolo, the Supreme Court stated thus, and I quote, a consent judgment means when the parties only equal to the court as a basis for the court judgment, by the mutual agreement to settle the matter, they have given their consent to end the litigation. That makes it a consent judgment on court. But by the very nature thereof, a consent judgment is fundamentally a contractual agreement between the respective parties. In effect, a consent judgment considers a final decision of the court, which can only be appealed against with the leave of the court. See the case of Ulichem and Okoma. The rule is that actions may be settled by a consent during the trial. Usually, such settlement is a compromise, and in order to have a binding effect on the parties, it is imperative that it should have the blessing of the court. Settlement between the parties may be described as a contract, whereby new rights are created between them in substitution for and consideration of the abandonment of the claim or claims pending before the court. When the court moves and takes action as agreed upon by the parties, it becomes a consent judgment. In such a situation, the court may give judgment or make an order of discontinuance or may order a stay insofar as the circumstances of the case may permit. I need to mention that since according to the Samson Statement Exhibit MCD 11, which was entered at consent judgment, Exhibit MCD 10, that the 8th claimant was said to have been paid his wages and his claim completely settled, then he cannot come back to claim any wages against the defendant in the instance case. His only option is to apply to set aside the consent judgment based on genuine and acceptable grounds or appeal the judgment. In the light of that, the case of the 8th claimant against the defendant ought to be dismissed, and I so order. For the claim of the remaining claimants, my concern and question, as I have read earlier, is that how can 8 of them claim the sum of $105 which is higher than the sum of $100,000 entered as consent judgment meant for 15 plaintiffs? By Section 128 of the Evidence Act, content of a judgment or any other document cannot be contradicted, altered, or excluded by oral evidence. A claims are for their wages, and a claim for wages being monetary sum is a claim for special damages. By the provision of Section 131 of the Evidence Act, the claimant bears a tax to prove their specific claims. The law is that evidence ought to be laid before an award for special damage is granted. And to succeed in a claim for special damage, it must be claimed specifically and proved strictly. The fact that it appears to be admitted does not relieve the party claiming it of the requirement of proof with compelling evidence. In the case of NNPC and Clifton Nigeria Limited. The claimants still have the evidential burden to establish their claim for special damage with precision, not only rely on the weakness of the defense. See the case of Ekedare and Adebara. To prove an entitlement, as in the instant case, the claimant must refer the court to exact provisions of the law, instrument, or document that confer the entitlement. See the case of Mohammed Dungus and Consortium Limited. Although the defendant have no defense but a law generally, where evidence is uncontradicted, the onus of proof is satisfied or minimal proof, since there's nothing on the other side of the scale. However, minimal proof remains as such and does not mean no proof. The failure on the part of the defendant to give evidence does not exonerate the claimant from proving his case, though minimally. In the case of Lamy and Data Processing Maintenance and Services Limited. Claimants are referred to various email exchange between them and the representative of the defendant. Exhibit MCD 18, dated 13th December 2018, sent by the representative of the second defendant, one Phillips Matthew, said thus, and I quote, "Just out of curiosity, did you see the attached document which was a full and final payment received from the bank? It was an equivalent of 30% of monies being owed to us, bearing in mind that we spent 10% of the received sum in legal fees. That being said, please let your clients know that we shall be paying as received. The attached document can as well be verified by NIMASA. You cannot pay out what you didn't receive. We have to accept the loss to have the case closed and move on. Note that these funds were borrowed from the bank as evidenced by the court, and we couldn't even recoup half of it back on court. I believe this statement is essentially referring to the sums of settlement and the consent judgment as full and final payment entered by the Federal High Court. That is why it is stated in the statement that the defendant shall be paying as they receive, and they cannot pay out what they didn't receive. In the light of all the above, I find that the first and seventh claimant cannot be entitled to an amount stated in their relief, which is higher than the amount in the consent judgment entered by the Federal High Court. And even at that, and even that sum of 100,000 naira, 100,000 US dollars, do not belong to the first and seventh claimants alone. Rather, it belongs to the first to seventh claimant and other plaintiffs in the case at the Federal High Court. Accordingly, I order that the defendant shall calculate and pay the first to seventh claimant their wages out of the 100,000 US dollars that was an equivalent of 30% of monies being owed. I stated in Exhibit MCD 18, which is judgment sum in the consent judgment given to the first to seventh claimant and other 8 plaintiffs in the case before the Federal High Court. A cost of 500,000 is awarded in favor of the claimants against the defendants. Judgment is entered accordingly.
My Lord, I can but thank you. I can but thank my Lord. I think it required critical reasoning, and my Lord demonstrated that. And I thank my Lord.
Yes, what I said was that since that 100,000 USD,
yes,
given as consent judgment,
yes,
it meant for
all the people there.
All the people there.
Yes.
So the defendants are ordered to calculate.
Yes.
Because according to what Mr. Phillips Matthew said,
yes,
it was an equivalent of 30%.
Yeah, 30%, yes.
So that 100,000 USD belongs to in everybody there.
Yes, madam.
The seventh claimant here, first to seventh, let them calculate the 30% of what they are entitled to out of that 100 USD.
It makes sense, my lord. It makes a great sense.
And give it to the first to seven.
Thank you, my lord. That is justice in action.
Yes, but for the eighth claimant,
I agree with my lord. Perfect reasoning, perfect legal reasoning. The only thing you can do is to apply to set aside that judgment because it is based on false premise.
Yes. So that's what
I agree, my lord, and we are very grateful for
so
this judgment.
So you can now go and begin to enforce the 30% of the of the out of the 100.
Yes,
USD
my lord. I agree, sir. I agree, my lord. We are very grateful, my lord. Thank you so very much, my lord.
Thank you so much, Mr. Mobara. I'm so grateful.
Thank you, my lord. Thank you. I'm grateful.
So I'm going to send I'm going to send the judgment to the registrar to print out and give it to you.
Thank you, sir. I appreciate. Yes. Thank you, my lord.
Okay. It's okay. Thank you so much. Bye-bye.
Thank you, my lord. Thank you.
Okay. Thank you.